So item number 15, 16, and 17. These matters have become infrastructure. Yeah.
Anyone from the GMC?
I-
Okay. Sri UK Goswami Learned Counsel for the petitioner has submitted that by flux of time the matters have become infructuous. Para. Also heard Miss M. Burman, Learned State Council, and Sri S. Bora, Learned Standing Council, GMC, who do not so stop. Huh? Also heard. Para. In view of the aforesaid submission, matters are closed as infructuous.
Again.
At our order.
May it please, Madam. My lord, I beg to mention item number 19, my lord. My learned friend is the other side. There's some developments in the case, lordship may fix the matter after the due vacation, my lord.
I have no guess. I have no, I appear from GMT.
Okay. Sri P.K. Roy, Learned Senior Counsel for the petitioners, has submitted that there are some developments, and accordingly he prays for some time to apprise this court about the same. Para. On request, also heard Miss So-and-so and Sri So-and-so, huh? Okay, GMD. It was GMC number GMD, M. Burman, State Council, and GMD as well. In view of the above, list after the winter vacation.
Due vacation.
View,
Oh, sorry, I'm sorry, I extended.
Winter vacation. yes.
May I please, your lordship? Lordship, with the concern on the other side, I beg to mention item number 18, your lordship.
18,
Yes, lordship.
yes.
So we have need some instruction, your lordship, in this matter, your lordship. Matter in past. It's after vacation, your lordship.
What about the respondent 7, 8?
I mean for the respondent.
On a request made on behalf of the petitioner, matter is adjourned to be listed after the winter vacation.
Lordship.
Lordship, can I pray for a fixed date?
What is the matter about?
Lordship, this matter pertains to eviction, Lordship.
Eviction.
Yes, Lordship.
You are protected by an interim order.
No,
They are
Lordship.
protected by an interim
Yes,
order.
yes, Lordship.
Okay. Then we say list on when 8th on
Yes, Lordship.
8th of January.
I'll oblige, Lordship.
Right, please, your lordship.
Hmm.
Lordship, with the council, with the consent of the council for the petitioner lordship, I'd like to mention item number 51.
5-1.
51 lordship. In
Yes.
this matter, I have been newly engaged by the respondent number 1 and 2, the Jorhat Development Authority lordship.
5-1 is a supply list.
Supply list lordship.
Yes.
So, I've been engaged by the respondent number 1 and 2 lordship.
Yes.
So, I would like to file affidavit. So, I pray for 2 weeks time lordship in this matter. I have taken consent for the
Okay.
petitioner.
Okay.
In this matter, my name may be struck off because last occasion, no such representation on behalf of 1 and 2. So I was instructed by the
Doesn't
honorable.
matter. On the request of Sri P. N. Sharma, Learned Counsel for the respondent numbers 1 and 2, matter is adjourned by 4 weeks to enable filing of affidavit in opposition.
Lordship. Much obliged.
Yes.
May I please, your lordship? I beg to mention item number 25, my lord.
The name of Miss M. Burman, GA, may not be reflected in the cause list. Yes.
Lord, I beg to mention item number 25, my lord.
Yes.
We need to file a rejoinder against the affidavit in opposition filed by the respondent side, my lord. I have taken consent from the respondent also.
Here for the petitioner,
I am for the petitioner, my lord.
on a request made
1 week time, my lord.
on behalf of the petitioner,
1 week.
a week's time is granted to file rejoinder affidavit.
My lord, item number 48 and 49 is similar matter, my lord. So maybe fixed together.
When?
48, 49,
You want say adjournment in 48, 49 also?
yes. my lord.
You'd like to file rejoinder?
Yeah. No,
Say-
in the 48, 49, I have filed, my lord. Already filed.
So do that there, why are you seeking adjournment?
My lord, similar matter, that is why, my lord.
Similar with
Similar
which?
matter, similar,
Similar with which one? Other one?
yes, my lord.
48, 49.
Similar with 25?
Land acquisition matter, my lord.
Similar with 25?
Yes. ma'am.
Okay.
Earlier it was clubbed together.
48,
but subsequently
49.
segregated.
On request made on behalf of the petitioner, matters are adjourned by a week.
Yes, ma'am.
Have you
Date
taken
may
the
be fixed, my lord.
consent of the other party?
Yes, my lord. I have taken consent, my lord. My lord, can a date may be fixed, my lord.
We have said 1 week for filing rejoinder
Yes,
in the other, we'll come together.
Can
Okay.
it be on 17, my lord? December.
December, not be possible. Last week will not be possible. Will not give a date. If it is, it's good. Okay. Yes,
Prayer for listing of a motion matter on Wednesday, my lord. I am deeply obliged.
Please, your lordship. I beg to mention item number 28.
28.
Yes, lordship.
Yes,
Lordship, this is an eviction matter where we are looking to file an rejoinder against the affidavit filed by the respondent number 4.
hmm,
So kindly 1 week's time may be granted.
okay. On a request made on behalf of the petitioner, matter is adjourned by a week to enable filing of rejoinder affidavit.
Lordship may kindly give me a date. Next week if possible.
Next week is the last week. It will not be possible. Last week before the vacation will be motion. Okay, 15th we'll try. 15th. 15th.
Obliged, madam.
May please, your lordship, I beg to mention item number 38. This has been wrongly listed in admission column. This matter may come, is listed in motion matter. Let the matter may come up on Wednesday.
We'll have it for motion. What is the difficulty?
I have to inform the other side.
Other side, when
Social welfare, and
they'll be there. What is the difficulty?
after the completion of the main. motion.
Yes. From 38 to so.
May I please, Lord?
Just a minute. 38. कैमरा को आउट तल रहे सब म पोर्ट कर दिए ना कैमरा तो ऊपर रहे दिस पोर्ट कर दिया फॉर्म में पोर्ट कर और okay, we'll have it for motion. You inform the other side. Unless you have some grave difficulty, we'll have it. Okay. Next, yes,
Item number 21 and 22, Lordship.
yes.
I have taken consent from the other side also. I kindly adjourn for the day, Lordship. Item 21, Lordship, we are petitioner, and item 22, we are respondent. Connected matter, Lordship.
On a request made by the learned counsel for the petitioner in item in WPC 6133 2023, who is also the respondent in the connected with petition, matters are adjourned by a week.
Yes.
Yes.
All right.
May it please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 20, lordship.
20.
Lordship,
Yes.
here we are yet to file an affidavit, lordships. Your
You are
lordship,
for whom?
KAC, lordship.
KAC.
Yes, lordship, on behalf of Mr. J. Chicken.
Okay. Taken the consent. 23 matter you have not filed affidavit.
Lordship.
A request has been made on behalf of the KAC for adjournment to enable filing of affidavit in opposition. Para, considering that this matter is pending since the year 2023, our last opportunity of 4 weeks is granted to file such affidavit. List after 4 weeks.
Obliged, lordship.
Yes.
May it please, your lordship, I beg to mention item number 11 and 12, your lordship.
Yes.
Mrs. PK Tiwari, Mrs. Senior Advocate PK Tiwari, who is leading in item number 11, is indisposed, your lordship. Is unwell.
Okay. 12 is connected.
12 is connected.
I am appearing for the petition, interim is there, 12.
Okay.
12.
On a request made on behalf of Sri P.K. Tiwari, Learned Senior Counsel, matters are adjourned to be listed after the winter vacation. Para, interim order passed earlier to stands extended till the next day of listing.
Obliged, your lordship.
I believe, Lordship. Lordship, I beg to mention item number 23. Kindly pass over for the Lordship.
23?
23.
Yes. For whom?
I am appearing from on behalf of Anju Datta,
For the petitioner.
petitioner.
Why do you want to pass over?
My senior is out of station.
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed after a week.
May I please, lordship, I beg to mention for listing, my lord, any date for.
Listing what? For what?
Listing for admission, my lord.
Admission matter of which year?
25, my lord.
What matter? What is the urgency?
Lordship, there is disqualification of Panchayat, Gaon Panchayat member.
Not urgent matter. Sorry. Yes.
After, lordship, after vacation.
Sorry. Mention memo for matters other than motion, there has to be some urgency.
After vacation, my lord.
You approach the registry, not the mention memo.
My lord, I beg to mention, mention for admission, my lord. After the vacation, my lord, may be listed, my lord.
What is the urgency?
Or, my lord, regarding the husband of the petitioner, my lord, died, my lord, due to the killing of.
These are not urgent matters, sorry,
After the vacation.
sorry. Next.
Lordship, in item number 52 of the supplementary list, an
Yes.
affidavit of position is being filed by respondent number 8 and 11. That may be called for. Lordship.
Yes, please do.
Obliged, Lordship.
My please, Lordship. Lordship, I beg to mention an item for listing for admission. Lordship,
What is the urgency?
the urgency is that Lordship, a land was acquired via auction. But it's been more than a decade, Lordship, neither the possession.
This is not an urgent matter. Urgent means something is going to happen tomorrow, not like that. Yes,
Yes, may I please, Your Lordship? I would mention for listing and motion matter.
motion is, motion, no problem.
Obliged.
Lordship, if it may be on next week.
Sorry, madam, we are maintaining a policy, motion, no problem in listing, admission orders unless there is urgent, not by mention memo.
Obliged, Lordship.
Urgent matters, yes, we'll definitely consider.
May I please, Your
Yes, Mr. Das?
This is for this, which is evidence of the order dated 28/10/2024. Passed in WBC number 2594/2010. My lord,
How much time was granted?
my lord,
How much time was granted?
3 months time.
3 months.
Page 29, my lord. of
20?
the first- 29, my lord.
29.
My lord. Para 24,
Para
24,
23,
24, my lord.
24. Because there was a release the balance contract. Heard 3 UK Das learned counsel for the petitioner who by means of this application has complained about willful and deliberate disobedience of the order dated 28/10/2024 passed in WPC 2594 of 2020, full stop. The learned counsel has also drawn the attention of this court to the communications issued to the respondents requesting for compliance of the order in question, full stop para. That notice be issued returnable by 6 weeks. That steps be taken for service of notice by speed post with AD, steps within 2 working days.
May I please, Your Lordship?
Yes,
My lord, operative part of the order is with page 12, my lord.
well,
Direction to the BTC authority for compliance of the order, my lord, within a period of 2 months.
where is your communication?
My lord, communication is.
Okay,
in
same
the
order.
Starting,
J Sharma. J Sharma, order dated 28/3/2025, WPC 7068 of 2025. Notice 6 weeks. Yes, take steps by speed post with AD within 2 days.
Obliged.
Yes, Mr. Nath.
May I please, my lord? The operative part of the improved direction is at page 53, my lord.
50.
3. Roman 2, my lord. Para Roman 2.
Which is your writ petition?
My lord,
This was passed in a bundle of writ petitions.
my lord,
Which is your writ petition?
my lord, my repetition is 4465, my lord.
What was the direction?
Direction was the assistant commissioner was directed to pass fresh assessment orders, my lord. Within a
Not-
period of 6 weeks, my lord.
Not done.
Not done, my lord, yet not done. And 2 occasions we have communicated the orders, my lord.
Okay. D.M. Natha, WP, in the order it is so and so, 21/2/2025, passed in a batch of writ petitions, including WPC 4465 of 2024, correct?
Yes, madam.
Perhaps of back representation, then issue notice. So you take steps,
My-
state post-critic within 2 working days.
My
Okay.
lord, my lord. My application, my lord, 424022, my lord.
Not that one.
No, no, my lord.
You had given a
My
wrong
lord.
number, why?
Dear my lord. 424022, my lord.
You don't know. 4,
240.
4240.
Yes, ma'am.
এইটো নহয় দে 4465 নহয়। Four two four zero is the petitioner.
Yes, ma'am.
Present petitioner, okay.
Yes, ma'am. But
Yes.
My lord, in this case, I have purchased the, my lord, the flat in question, my lord, on
There is a
7th.
caveat.
Yes.
Mr. Ahmed, you are appealing for the caveat. Let us discharge the caveat then.
5 to 12.
Heard Sri Ahmed, the London Senate Council assisted by Sri A.M. Datta for the caveat which has been lodged in connection with an order dated 17/6/2025 passed by the learned Assam Board of Revenue in case number 53 RA within bracket DIB bracket close to 2023 full stop. The caveat would be heard in the event this court proposes to pass any interim order. Para, caveat stands discharged. Yes, Mr. Fat.
Well, the sale deed was executed on 7/4/2022.
There was a sale deed.
Sale deed, my lord.
Who are you?
Yes, I am the bona fide purchaser. of
You are the
my lord,
purchaser.
from the promoter who had a power of attorney.
Sale deed was registered.
Yes. Registered accordingly, my lord, the mutation was also done on, my lord, 15/12/2022.
Hmm?
Mutation was also
Which date?
15/12/2022.
Mutation, your name is mutated.
Mutated.
Okay.
Then,
Thereafter,
my lord, a complaint has been filed by the owners saying that they have revoked the
owners of the land.
owners of the land. Power of attorney was on the, my lord, promoter or the
developer.
Developer.
Okay.
He has sold it, my lord.
Okay.
Now the complaint has been filed before the, my lord, additional deputy commissioner by the owners that they have revoked the power of attorney on 25/9/2022.
25.
9/2022.
When was the deed registered?
7/4/2022.
7/4/22.
22. During that time, my lord, the power of attorney was valid.
Oh. And this 25/9/22, the power of attorney was revoked.
Revoked. And on the basis of that complaint,
Yes.
my lord,
This 25/9 was the complaint.
no, it was the date on which
Revocation was done.
revocation was done,
And thereafter it was followed by a complaint.
followed by complaint.
Okay.
And based on the, my lord, complaint, my lord, on 25/4/2023,
Yes.
the additional deputy commissioner, my lord, has cancelled the, my lord, mutation without there being any notice to us on the ground that the notice in the earlier, my lord, while mutating the name, notice was served on the power of attorney. Now we do not know whether power of attorney holder had the knowledge of revocation or not. But nonetheless, my lord, the sale deed was executed much prior to the revocation of the, my lord, the power of attorney. So since it was cancelled, we again, my lord, approached the, my lord, additional deputy commissioner that without issuing any notice, we have cancelled already the mutation which was granted. Then the additional deputy commissioner, my lord, recalled the order, my lord. Recalled the order by which he has cancelled the earlier mutation order and directed the parties to, my lord, go to the civil court. Now, challenging that, my lord, they have approached the revenue board. And revenue board, my lord, has cancelled the, my lord, mediation order based on his finding that this, my lord, sale deed as well as, my lord, the power of attorney, all these things, my lord, are doubtful. Rather, my lord, questioning the validity and legality, my lord, doubting the legality and validity of those, my lord, documents, my lord, and advise the present petitioner to approach the civil court. So that is the what, my lord, the illegality has been committed by the revenue board, my lord, questioning the validly registered sale deed as well as the, my lord, mutation which was in fact, my lord, was granted according to the law. If any, my lord, complaint was there that no notice was served, at best, my lord, it could have been relegated to the, my lord, additional deputy commissioner to hear the parties and, my lord, proceed with the matter. But here he has gone to the extent of doubting all the, my lord, sale deed, etc.
Let us see those observations
My lord will
of
find
the ADR.
Order dated 17/6/25 at page 183, 17/6/2025. 183,
183.
page. Lordship may come to page 188. Or Lordship may 187 almost also. May I read, my lord?
Just a minute. One 188.
188.
Yes, please. Which part?
My lord, from paragraph 14 onwards, my lord, from top, my lord. Section 52 ALRR requires that any mediation application must be preceded by notice to all persons interested in land. Share so-and-so claim by the respondent number 4 derives from schedule so-and-so and the schedule G common places. None of the appellants received notice. Only respondent number
So what
5.
is the, okay, we have seen it.
Look,
What is the present status now? You're late in approaching the court.
my lord, little late, my lord, pursuant to this, my lord, the correction has been made. So far as my name is concerned, that has been deleted. Now,
Yes, Mr. Amit. We'll issue notice at this stage. We'll notice at this stage. You are the owners of the land.
Is the owner of the adjoining plot.
Adjoining plots.
Common land is one plot, been divided among the brothers, and there is a common passage. What was done was the common passage was included in the mutation. As against us, and without notice to us.
Their projection is slightly different, Mr.
but he is perhaps he is representing respondent 5 to 8.
5 to 12.
5 to 12. 5, 7, 8. They have, my lord, made an agreement with the respondent number 13 with respect to, my lord, plot measuring 3 katha and odd.
No, who's the owner? Who's the owner of the land on over which the building, the flat has been constructed?
5 to 12.
5 to 12.
5 to 12.
But he is saying, Mr. Ahmed is saying something else.
No, so far as
That they are having the adjoining plots and even the right.
so far as my lord, 3 katha is concerned, that's exclusively owned by 5, 7, 8.
Okay, let us see. Heard Sri P.J. Saikya, Leonard Senior Counsel assisted by Sri Gupta for the petitioner. First up, the petitioner has put to challenge an order dated 17/6/2025 passed by the Assam Board of Learned Assam Board of Revenue, whereby the appeal filed by the respondent numbers
5 to 12.
5 to 12 have been allowed, has been allowed. full stop. It is the case of the petitioners, one petitioner, a petitioner that vide a registered sale deed dated 7/4/2022. The property was purchased, followed by a mutation order on 15/12/2022. Full stop. However, the said mutation was cancelled on 25/4/2023 on the ground that the power of attorney given by the respondent numbers 5 to 12 was revoked on 25/9/2022. Full stop. Since notice was not served on the petitioner, the petitioner had approached the ADC, learned ADC, who had recalled the earlier order of cancellation dated 25/4/2023. And this action was the subject matter of challenge in the appeal preferred before the learned ABR. Full stop. Para. Let notice be issued, returnable by 6 weeks. Who's taking one? Okay. E.R. Mohanta, Revenue Department 1. District Commissioner, you will take. Sharma, let's additional scenario for 2, 3, 4, and 5 to 12.
We have 5 to 4.
5 to 12. Sri M. Dutta, assisting Sri Ahmed Dalan Senior Counsel for the caveat of 5 to 12. What about the others?
Notice in the.
13, 14? 13 of course, 13 notice will go. Steps for service of notice upon the respondent was 13 and 14 were taken by speed post to TNA. Steps within 2 working days. Our report extra copies are 3.
The status quo with regard to the.
3. Saikya Dilan Senior Counsel prays for an interim order, which however is resisted by Sri Ahmed Dilan Senior Counsel for the respondables 5 to 12. Full stop. Para. Considering that the impugned judgment is of considering that the sufficient time has elapsed since the impugned judgment dated 76/2025, while this court is not inclined to pass any blanket interim order, it is provided that status quo as on today be maintained till the next returnable date.
Also, may I pay for an observation for disposal because this.
Disposal of what?
Of the entire writ petition because this property was in the bank mortgage. Now bank is asking us for a correction.
Let them after they'll have a chance to show cause at least. You find your affidavit.
I did find.
Look material to proof notice.
Wait, please.
Item number 5. What is this?
Wait, please. Lordship, matter is infructuous.
Infructuous.
Yes. Eviction was done.
Your SK Hajam. I heard 3 A.K. Hajam Learned Counsel for the petitioners. Also heard 3 D. Gogoi Learned Standing Counsel Forest Department, as well as 3 H. Sharma. H. Sharma, H. Sharma, Learned Additional Senior Government Advocate Assam, and 3 D. Gogoi Learned Standing. The Learned Counsel for the petitioner has, however, informed that during the pendency of this case, certain developments have taken place for which the writ petition has become infructuous. Full stop. And the petition is accordingly closed as infructuous. Yes.
Please.
Yes, item number 6. S. Islam E.R. Mondal. None appears for the petitioner on call. whereas the respondents are represented para in the interest of justice. Matter is adjourned to be listed on Wednesday. Yes, Mr. Hawk.
Well, matter partners, well, one session of adequate compensation, my lord. Here, my lord, the Jirat value, my lord, against the petitioner's property, my lord, that was not considered as per law, my lord, as well as, my lord, the valuation of the land, my lord.
It pertains to acquisition of land.
Yes, my lord.
You don't,
It will go to reference, my lord. He can take this under protest and therefore, my lord.
there's
My
a,
lord, here already.
That's the law, my lord.
Yes, yes.
you
Here
can
is
go
the-
for a reference. That is the, that is how the reference court will assess.
Otherwise, my
You
lord,
cannot assess.
My lord,
nothing
if
will
you-
come out from this.
Mr. Hawk, even if you have a good case,
my lord.
you cannot adduce evidence here so that we
Yes,
can
yes,
appreciate.
my lord.
You approach the,
My lord,
Yeah, they have to know.
paragraph 35, my lord, page 35, my lord, here already raised protested, my lord. But
Yes?
that was, paragraph, page 35, my lord.
35.
Yes, my lord.
Yes, what is there?
Here, my lord, the petitioner raised a protest, my lord, but on that part, my lord,
This is,
yes.
this, my lord, he'll have to
It-
file a case, my lord.
Yes, ma'am.
This case would have been referred to the, my lord,
15 October 2024.
yes, my lord. But they have not yet taken any action on this, my lord.
Yes, what do you say?
Yes, my lord, with regard to this, my lord, I can, your lordship can direct it if it's to pass a necessary order.
You take instructions and we will issue a short notice.
My lord.
Because this appears to be of October 2024.
Yes, my lord.
He has approved this code quite late. Okay, you
Yes, yes, yes.
issue a short notice, okay? Heard Sri S. Hawk Learned Counsel for the petitioners who are aggrieved with regard to the adequacy of the compensation for land acquisition.
Land as well as Jirat value.
Full stop. The for land acquisition, full stop. The claim is on the aspect of the compensation as well as for the Jirat value.
Jirat value.
Para? The Learned Counsel has also drawn the attention of this court to a communication dated 15/10/2024
By the petitioner, my lord.
names are not there.
Petitioner number 1, my lord, Jayant Kumar Das.
Submitted to the District Commissioner Borpeta, which according to the petitioner has not been acted upon.
Right.
Para? Let notice be issued returnable by 4 weeks.
1 and 2 mean.
Are you the member of the same family?
Yes, there are different,
Then how do you make a common replication for reference?
my lord, out of them, cause of action, my lord.
It will be different reference.
My lord, this,
Same family, yes.
yes, my lord. The-
Then we have seen
my
that.
lord, this reference, my lord, that petition, my lord, that was filed on behalf of the locality.
Cannot do.
My lord, this won't survive, my lord. So, my lord, it's not a reference application also, if you also come to the contents of the application.
We have seen that, but not been acted upon. It goes on. 4 weeks. 3 SK Medhi, Learned CGC for 1,
1 and 2.
1 and 2.
3, 4, 5.
It is for the railways. The acquisition is for the railways.
Yes.
Yes, my lord.
Then 3 and thus Learned State Council for 3, 4 and 5.
Five.
That extra copy will be served by tomorrow.
My lord, status quo, my lord.
Status quo what?
My lord, otherwise, my lord, they will demolish, my lord.
Status quo, how is this with status quo connected with your? You will get more value, you may not get more. How can you prevent them from acquiring?
Basis of, my lord, they want more money, my lord.
My lord, even if my lord lordship, for a second, my lord, just page 34, your lordship goes to page 34, my lord. What they have done, my lord, is the Jirat bill, my lord. First, they have,
Mr. Hawk,
my lord,
you want more money.
my lord.
For that, can you hold the project?
No, I am not.
Then
on that, my
status quo
lord.
what? Status quo
Because
for what?
they can demolish the building, my lord.
That you cannot prevent. You whatever is your amount entitled, you will get. That will ensure.
Yes, reference code will determine.
My lord,
Reference will determine, my lord.
my lord,
My left.
oblige.
Yes, next.
Have been lost.
Yes.
In this case, my lord, the petitioner has challenged lordship. At page 14, ordered, my lord, so far as respondent number 7 is concerned, lordship. Kindly see at page 14, lordship. My lord, fixed pay was given to the person, so my lord, joined prior to 2005, lordship.
Who are you?
My lord, I am aspirant for the said post, my lord, in the event of my lord, filling up the post by open employment system, recruitment process, lordship. Because
Where
my
is
lord,
your qualification?
he, my lord, my qualification, it is a peon, lordship, peon.
Now,
my
what
lord,
is your qualification?
qualification I have not stated, but in the, my lord, paragraph 13, I have stated, lordship, my lord, by this much
Unless
I
you
have been
show that
approved.
you, unless you show that you are eligible and
Then
qualified,
I'll file additional.
you have to file.
Lordship.
You cannot, you have to have locus.
But it is, my lord.
No, you may be having a good cause.
He
That
did,
person.
he did never join in service prior to, my lord, 2005, lordship.
This
Now,
can be examined when
that's
an,
2000
this can be examined when an appropriate person comes before the
Yes,
court.
lordship.
You show your entitlements.
I'll file, lord.
Will, okay.
My qualification.
Okay. Heard Sri M. H. Ahmed, learned counsel for the petitioner who has put to challenge the order of engagement of the respondent number 3 as peon. Full stop. It is alleged that such engagement has been done on the basis of fabricated and doubtful records. Para. The petitioner has, however, not stated his. Though the petitioner, though on a specific query put by the court, the learned counsel has submitted that the petitioner is also an aspirant, his qualification has not been stated in the writ petition. Para. Sri Ahmed, the learned counsel prays for and is granted 2 weeks' time to file additional affidavit in this regard.
Lord, all right.
May I please, your lordship? This petition is relating to non-payment of ex gratia relief. My husband was a fisherman, belongs to Koiborto community as sea. He went for fishing in Bogdoi River and accidentally died.
Yes, is it covered, madam?
Oh, no, lordship.
Huh?
No, lordship. As per judgment of Tasliman Nasrin, my lord, where is public place is defined, redefined, my lord. So, I mean, it is a benevolent scheme, my lord. His case doesn't cover, my lord.
Lordship, page number 28, public place
Where
is
is, there
defined.
must be a public place.
Lordship, similar case.
No, earlier, the concept was different. It cannot be a matter of rule that whatever accident, not on, okay, we'll issue notice at this stage. Your Ardeka, Heard Sri Ardeka learned counsel for the petitioner who has approached this court with a claim for ex gratia payment on account of the death of her husband, full stop. It is submitted that the husband of the petitioner had gone for fishing in the Bhogdoi River in the district of Jorhat and had drowned accidentally on 28/8/2020. Put the para. Let notice be issued, returnable by 6 weeks. Ms. J. Hadarika, Standing Council, Revenue Department for 1. Finance, Chaliha, A. Chaliha for 2.
345, I am.
And M. Borman, State Council 345, full stop. The learned counsel for the respondents have, however, submitted that the present case would not come, that the petitioner would not be entitled to the ex gratia in as much as the place of accident is not a public place. Full stop. Para.
Respect, my lord, WPC.
The said issue would be considered at the appropriate stage. Para. Extra copy report, Lisa.
Obliged.
May I please?
Yes.
Lordship, as per the last order, my lord, 3/12/2025, one question raised regarding, my lord, maintainability of the regarding the state of
filing this petition under section 220, article 226, NGT is the appropriate forum, my lord. In this regard, I have gone through the NGT Act, my lord, as well as one division bench decision of the Delhi High Court, my lord. I satisfy your lordship, my lord. When, my lord, with a very limited prayer, we are the instant petition we have been filed under Article 226 regarding, my lord, certain the Star Cement is going to propose to set up a mega project there, my lord. In this regard, we made various RTI application, my lord. They have not replied on in details, furnished all details information. Then we made a representation complaint on 29 August 2025 to conduct an inquiry, and whatever document we sought, they may be furnished, so that we could arrive that is there any violation or not. If there is violation, then NGT is the appropriate forum, then we can approach before that forum, my lord. That stage not yet has come, my lord. So, lordship, kindly have a look there.
What do you seek in this petition?
Yes, my lord. Lordship, if you take you directly my prayer, my lord, at page 16, I'm skipping by prayer number A, my lord. B only. I'm dealing only B, not on A and C. Though it is written an interim, but it is at this stage I am praying only B, my lord. They prayed that before the lordship directed respondent or to hold an independent inquiry into the matter so as to find out under what circumstances the said cement factory was allowed to be set up and
But don't
whether.
you think that this is the nature of a public interest litigation?
My lords, exactly, my lord.
My lord, if
Locus has to be questioned, my lords.
Lordship, if lordship has seen my prayer in my complaint petition, then lordship will, whatever lordship will say, I will leave it up, lordship. My complaint, lordship kindly have a look, my lord.
And this has to be in the nature of a PIL.
Yes, ma'am.
Because in a PIL, though the aspect of locus is diluted, there are certain other aspects. Your bona fide will have to be, you have to prove that you have bona fide approached the court. You file it in the way of a PIL, we'll examine.
My lord,
That NGT thing may not be an absolute bar at this stage.
Yes,
That
sir.
is our opinion.
Yes, yes.
But examining on the basis of an individual in a writ petition, where prima facie your
well, we both petitioner belong to that concerned locality, my lord.
understood, you can espouse in the way of a PIL, will grant you the liberty. We cannot ask for converting because PIL, you have to meet many other requirements. You have to give undertakings regarding your bona fide, your ability to pay the cost.
Yes, lordship.
Heard Sri P.K. Dekkar, learned counsel for the petitioner. Also heard Sri H. Sharma, learned additional synagogue advocate. Sri D. Gogoi, learned standing on the forest department. And Ms. G. Bora for agriculture department. You are for, madam? Who is it?
Joint Director Health Services.
For health department. On behalf of whom? What is your name? B. Bora on behalf of Bomani for the health department. Anyone else? Pollution control? Who is there for PCB?
Yes, Bora, my lord.
Is he around in the court?
I have not seen him.
Last day they
You
appeared.
must have seen him on TV, not in the court.
Yes, Bora.
I'll inform him.
Yes, Bora, my lord.
He is more prominent in televisions nowadays. Is he changing the profession now?
No, my lord. Simultaneously.
Simultaneously.
Yeah.
As Bureau for the Pollution Control Department. For the para. On a perusal of the cause of action sought to be espoused, it appears that it is more in the nature of a public interest litigation. Para. At this stage, Sri Dekkar, the Learned Counsel, submits that he would like to withdraw this petition and has sought for a liberty to file it in the form of a public interest litigation. Para. In view of the above, petition is closed on withdrawal with liberty as paid for full stop. The petitioner is, however, required to meet this, meet the standards. It is, however, necessary for the petitioner to meet the requirements to file such a PIL.
Yes, deep blue. God bless.
44. Yes, Mr. Hussain.
Victim compensation, my lord, page 25 onwards, my lord, whereby the DLF has passed an award, my lord. Page 25, operative part, my lord, page 26, bottom. Bottom, last line. Considering the facts and circumstances, I am of the opinion that applicant so and so, so and so. So and so are entitled to receive compensation from Assam Victim Compensation, so accordingly, so and so, madam. But although,
Where's victim compensation? Why one has to come to the court?
and
Madam Borman,
I have to obtain
no,
instruction.
no, no, instruct your client, instruct the state.
My lord.
One is not required to file a writ petition for victim compensation. That would be it would be against the entire scheme of
Yes.
the objective of the scheme.
Scheme.
If one is required to come to a court to seek victim compensation, that will be add to the misery. The entire scheme is it's a kind of a solitude,
Yes, ma'am.
solace that somebody has suffered. You are not required to force somebody to come to the court. The recent case, Honorable Supreme Court has come very heavily. There should not be any delay. Of course, in bona fide matters, there should not be any. You take instructions, short notice, 2 weeks, okay?
and
Third.
the- my lord, similarly situated matter already disposed of by the coordinate bench, my lord, I have annexed page 28.
On the motion stage,
My lord, initially instruction was called.
some notice has to be given.
My lord.
We don't even know your bona fide. We are not doubting anything, but still let them have the notice. Okay.
My lord.
Third, Sri M. Hussain, learned counsel for the petitioner who has approached this court for in connection with victim compensation. Para? Let notice be issued returnable by 3 weeks. 3 weeks only happening before the election, now you know. Returnable by 3 weeks, 40. Home political, madam, you, Burma, 1,
1, 4 and 5.
1, 4 and 5 finance, H. Aliya for 2. 3, Assam State Legal Service.
R. Chaudhary.
Where is she? Is she there in the court?
Our junior's name may be recorded as so.
Who is there?
I have seen.
Somebody has to be there in the court.
I have seen him.
Name?
As Sohan.
S. Chauhan on behalf of R.S. Chaudhary for respondent number 3. And DLSA, Tubri,
I am appearing.
you'll appear, okay. 5 also will be
Yes.
appearing, okay, okay. Let extra copies be served by tomorrow. Para? The learned counsel for the respondents are directed to obtain specific instructions with regard to the as to why there is delay in disbursement of the award. Full stop. While doing so, comma, the bona fide of the petitioner is also to be examined. Full stop. Considering the subject matter, comma, list this case for admission immediately after the winter vacation. We can give a date on 7th.
7.
7th.
Of this.
Yes.
A removal of the petitioner, my lord, of page.
Removal.
Yes, my lord.
From
Without
where?
any notice, opportunity and hearing, my lord. Suddenly, pass the impugn order, my lord. And that too.
Removed as what?
Ward member, my lord.
No notice.
No notice, no opportunity.
Yes, yes.
There is no notice.
No notice.
But inquiry has been conducted, my lord.
Behind back our petitioner, my lord.
Rescinded has been found. They have in fact,
Any my lord has to remedy, only remedies.
they are only
Election
awarded,
petition.
this is the election petition. It's admitted fact, such as she got 3 silver. There has been
Heard. the A.M. Ahmed Learned Counsel for the petitioner who is aggrieved by an order dated 21/11/2025 by which she has been removed as a ward member. Full stop. It is the case of the petitioner that she was elected as a ward member from ward number 6,
Raja
comma, Raja Gadhua Gao Panchayat in the district of Morigaon on 11/5/2025. Full stop. However, some enquiry was conducted behind her back, leading to the impugned order which has been passed ex parte. Full stop. Para. Let notice be issued, returnable by 6 weeks of all of the all the respondents would be are represented. Who 6 weeks? Who's doctor for 1,
1, 3, 6, and 7.
1, 3, 6, and 7.
2, 4, 5.
2, 4, 5. Okay, extra copies. What is the present stage now?
Stage my lord removed from the
From the order, it's lying vacant. Let it be removed. Page 31. The seat may be treated as vacant henceforth.
What kind of interim order can we pass?
my lord suspended the
new
implementation,
election.
my lord.
Huh?
As similar
No
to
new
the-
election maybe.
No?
New election.
By
Otherwise, as per act,
But will then on the returnable date will dispose this of.
my lord suspend the impugned order, my lord. A
Then
similar
election
situated person, my lord, approach this honorable court, my lord, same line, my lord.
already
Lordship
already
have the
removed.
interim order, my lord.
But you are already removed.
Yes, that also, my lord, earlier, my lord, child marriage is also related the same.
They were lucky.
Yes.
You are not.
Today
You
also
are,
lucky, my lord.
you are unlucky.
Today also lucky, my lord.
You have already,
Elected member, my lord.
you have already declared that you are lucky.
My lord, elected member, my lord, without any.
Then you have to do something to make you unlucky.
No, my lord.
You have already declared.
My
How
lord-
can you declare luck?
Lordship said.
Asri Ahmed, the learned counsel, prays for an interim order and has submitted that in similarly situated cases, comma, the interim orders, that the impugned orders have been stayed. Para. In the instant case, comma, it appears from the records that the impugned order was passed without giving any opportunity to the petitioner. Para. In view of the above, comma, till the next returnable date, the impugned order dated 21/11/2025 passed by so and so shall remain suspended.
Oblige.
It's a matter relating to the exemption of the previous year's evaluated tax lordship, exemption of previous year evaluated tax lordship, and allow the petitioner for registration of the.
Have you come to the right court? You perhaps have not come to the right court. Wine bar case in this court.
See, actually in the revenue board lordship, but lordship, they have issued so many impugned order lordship and page 27 lordship.
What is your cause of action?
Lordship, the respondent of the Government of Assam has introduced the Assam Value-Added Tax Lordship and Amendment Act 2015 Lordship. And as per this Act Lordship, the respondent authority had not issued any notification regarding the payment of an additional 6% of VAT Lordship.
Yes, what do you say?
Lordship, a similar matter was filed and challenging the imposition of VAT from retrospective dividend, and there's a notice was issued only there in Lordship. So let the matter be tacked with this one, the similar matter, Lordship, because.
Then will issue notice at this stage?
Yes, even in that case, notice was issued, Your Lordship.
Some protection may be given, Lordship.
Now, what kind of protection at this stage? Shri G.G. Gogoi Learned Counsel for the petitioner who is aggrieved by the action of the respondent authorities in making recovery of VAT retrospectively. Full stop. Para. Let notice be issued. Returnable by 4 weeks. Exercise, yes, R. Gogoi for
Respond number 1, 4, and 7.
exercise department 1, 4, and 7.
Yes, Your Lordship.
And finance taxation, 2, 3, and 6, A. Chaliha, Standing Council Finance, 2, 3, and 6. Then District Commission, and thus 5. 5, that's all? Good cover, isn't it? Take a stand. Let extra copies be served upon the learned council.
There is, because the main notification put to challenge, there is no stay in that, Your Lordship.
Page
There is
27,
no
Lordship.
stay in that.
Page 27, Lordship. Annex of 5, Lordship. They have already formed a task force, Lordship.
And the renewal to take place in month of March, Your Lordship.
While Sri Gogoi, the learned council has prayed for an interim order, the same is registered by the learned council for the respondents, who has also informed that in similar cases, notices have only been issued, and one such case is WPC 5652 of 2025. Para. In view of the above, this court is not inclined to pass any interim order at this stage, which would, however, be reconsidered on the returnable date.
Very well.
List along with WPC. WPC 5652 of 2025.
Obliged, Lordship.
Yes. The last what is this?
Lordship, it is regarding impugn eviction notice, my lordship.
Regarding
Eviction notice.
eviction,
They are
from
claiming-
where? Forest?
They are claiming, my lordship, this is forest, my lordship. But I have annexed some document, my lordship.
Already evicted?
No, it's under process, madam. It's a reserve forest of 1957. And
Have you issued notice?
Yes, notice has been issued, my lords. Interestingly, my lord, the documents annexed by the petitioner from page 21 to page 90.
Yes.
Lord, you will see the dates, my lord. These are more particularly, my lord, of 10, 11, 25. These are issued by some Gaon Pradhan.
Yes, my lord.
That is not a dispute, that area, but it's a forest area. Lordship, if Lordship takes this matter, we had done a joint survey also. If Lordship is inclined to take this matter tomorrow, perhaps I can come with instructions.
Okay, then we have it tomorrow.
Yes, ma'am.
We can have it on Wednesday. We got
Yes.
glasses.
Okay.
Third, Sri S.B. Laskar, learned counsel for the petition, Apara. Sri T. Gogoi, learned standing counsel forest, has however prayed for little accommodation to enable him to obtain the instructions. Full stop, para. In view of the above, matter is adjourned to be listed on Wednesday for motion.
Highly obliged, my lordship.
Thirty? No, to this. Yes, madam. Other side is there?
May I please, your lordship, by the impugn order is that page 19 Miller. By the impugn order, the respondent number 4 directed the respondent number 5 to cancel my caste certificate. Miller.
Something late for admission.
I belong to civil caste community, my lord. But
Just a minute, please. Yes, what do you say?
Lordship, regarding the petition which the petitioner has filed, she has made some false statement, Lordship, in the petition. Lordship, regarding in paragraph 16, page.
Was the mandate of Madhuri Patil followed
Yes,
before?
Lordship, yes.
No
yes,
enquiry report was furnished to me.
Yes,
Hmm.
it was.
No
Lordship,
enquiry report was furnished to me, Lord.
She has.
Okay,
stated-
will issue a notice at this stage. You get the instructions.
Yes.
I
Or-
didn't take him period, my lord.
Ms. S. Roy, learned counsel for the petitioner who is aggrieved by an order dated 31/10/2025, by which it has been directed that her caste certificate as scheduled caste is liable to be cancelled. Full stop. The petitioner has alleged violation of the requirement laid down by the Honorable Supreme Court in the case of Kumari Madhuri Patil versus so-and-so reported in 1994, 6 SCC 241. Para? Let notice be issued returnable by 6 weeks. You are for Mr. Das for 1,
1 and 4, Lordship.
1 and 4 Das. RM Das. Then District Commissioner Sri Bhumi, District Commissioner Sipsagar. 3, 2, 3 and 5.
Yeah.
M. Borman. Full stop. That extra copies, sir, be served during the course of the day. 3 Das, the learned council. Standing council is directed, it has submitted that the requirements of law have been duly fulfilled.
Yes, Lordship.
Full stop. He is required to obtain instructions and also produce the records
I have an interim prayer, my lord.
for cancellation.
Yes, my lord, because I am the vice president of Bharatiya Janata Party and I am because of this order, I am suffering a lot, my lord.
Not at this, the interim prayer would be considered under returnable bid.
Date may be fixed, my lord.
Tell us,
After due
on 19th January. Matter.
Your Lordship may kindly see the order dated 25/1/2023, Lordship, passed by this Honorable Court, Lordship. Wherein the respondent or Lordship assumed to file an additional affidavit, Lordship. But that was not yet filed.
To re-allot a piece of land in favor of the petitioner.
Lordship, earlier there was an affidavit from our side, Lordship, wherein it was stated that in favor of the petitioner was not passed by the subdivisional land advisory committee. Thereafter, I have gone through that order. Most probably, we have to take the updated instructions.
But this court had made an observation that no further adjournment.
Then in
Okay, we have it immediately after the vacation, but you get the info. instruction.
one instruction in 23, we have received. May I place this one, Lord?
Yes, what is that?
Most probably on this basis. Seventh of February 2023.
Your right emanates from which order? Which is the order? Your present claim has been made.
Because from this letter, it is seen that it is the reservation proposal in the name of the Khilamara Gaon Panchayat.
No, his The prayer is on the petition is basis on which order?
There is a letter dated 5/12/2025, Lordship.
Page
Lordship,
Annexure 13, page 40.
40.
Yes, Lordship.
What has happened thereafter? After this, what has happened, Mr. Laskar?
Thereafter, they have not taken any steps regarding reallotment.
No, this was in 2015, 5/12/2015. What is this mutation order? Cheetah copy at page 42.
My lord, I am extremely sorry, my lord, I have bring the wrong file, Lordship. If I will get, Lordship, the additional file, Lordship, because I have
Say
prepared.
that at the beginning. Okay, we'll have day after tomorrow. Try to dispose this.
Lordship.
Are you in touch with the clients or not?
Yes, Lordship, but I have prepared also, Lordship, but mistakenly, Lordship, wrong file.
Lordship.
Okay.
I will place it on that.
Okay, okay. On a joint request, matter is adjourned to be listed on Wednesday.
Lordship.
You can provide you.
Obliged.
Notice was issued as far back as on my lord, 2022.
Hmm.
And there my instruction is, Lordship, it is up to the PNRD department, Lordship, whether to allow him to run the shop or not, Lordship. This is my instruction.
But the impugn notice has been issued by the respondent number 2.
Notice was issued by the
Page
irrigation
35 and
department.
page 37. Page 35 and page 37.
Just a minute, please. Notice is by you.
Lordship, notice is by me. Today I have told by over telephone, Lordship, if PNRD department allows them to continue the shop, running the shop, Lordship, the irrigation department has no.
What do you say, Mr. Dutta?
My lord,
Are you still running the shop?
He is running the shop.
Lordship can dispose of directing the department, the Gaon Panchayat authorities, whether they will continue or not. Because before the notice, they will continue under the Gaon Panchayat, man. Now they are saying they are withdrawing their notice.
You'll be withdrawing the notice.
Lordship, I had the written instruction in that paper.
Okay, heard Sri A.K. Barua, learned counsel for the petitioner. Also heard Sri F. Datta, learned standing counsel PNRD, Sri Upadhyay, learned
1 and
standing
2.
counsel Irrigation Department,
No.
and any, if there is any government respondent also,
Respondent number 3, my lord,
Three,
the
Lord.
deputy commissioner.
and Sri H. Sharma, learned
3 and 4.
Additional Senior Government Advocate for respondent was 3 and 4. Para, considering the facts and circumstances involved. And also as agreed to by the learned counsel for the parties, comma, this writ petition which is pending since the year 2022 is taken up for disposal at the admission stage. Please have your seat. As per the facts projected, comma, the father of the petitioner had started a small rice hotel in Dabastan Bazaar at Hojai in the year 2005. Full stop. The petitioner is also relying upon an order dated 6/2/2014 issued by the respondent of 5 allowing construction of a shop in plot number 91 of the said market. Full stop. However, the Assistant Executive Engineer, comma, Jamunamukh Subdivision Irrigation had issued an eviction notice on 26/11/2021, followed by another notice dated 3/2/2022, directing the petitioner to vacate the shop. Full stop. The petitioner had submitted representation before the authorities, which was not considered, and accordingly, the instant writ petition was filed. Full stop. This court, while issuing notice, vide the order dated 11/2/2022, had also granted an interim protection, directing not to take any coercive action. Full stop. Sri Barua, the learned counsel, has submitted that the irrigation department would not have the competence to issue such eviction order. Full stop. In any case, comma, he has submitted that the such impugned action would also not be justified, inasmuch as the shop in question is at a considerable distance from the embankment. Full stop. He has also informed this court that pursuant to the interim order dated 11/2/2022, comma, the petitioner is continuing in his business. Sri Upadhyay, the learned standing counsel, Irrigation Department, has fairly submitted that though the notice was issued by officials of the department, comma, there may be a question of competence to issue such notice. Full stop. He has, however, submitted that such notice was issued bona fide and in the interest of justice and in the public interest. Sri Datta, the learned standing counsel, PNRD, has submitted that the aspect to continue or not to continue of the shop in question may be left to the PNRD department, as it is under this department, as it is this department which would monitor the subject matter in question. After hearing the learned counsel for the parties and upon a broad consensus arrived at the bar, comma, this court is of the opinion that the impugned order dated so is unsustainable in law and is accordingly interfered with. Full stop. It is, however, made clear that the appropriate authorities have the rights to ensure that the business run by the petitioner is in accordance with law and can take steps for any violation. The petition stands disposed of.
Deeply obliged.
Lord, item 14, instruction is not available, but they are on an interim protection line.
What is the writ petition about?
My lord, government has not filed affidavit.
So what is the writ petition about?
My lord.
What is the subject matter?
Subject matter, my lord, petitioner is petitioner one is a father of the petition number 2. my lord. One Surantanti was a uncle of petitioner. my lord. He was disabled person and unmarried. My lord, he Surantanti power of attorney given by petitioner number 2. Your Honor.
What is your cause of action? Why have you come to the court?
My lord, Eloit Panchop, this shop, Your Honor. My lord,
Where is your pawn shop?
my lord, Annexer,
Sipsagar.
Shipsagar, my lord. My lord, Annexer 1, my lord, page 16.
Sir, Doctor, this can be disposed of perhaps. What is the subject matter involved?
My lord, his subject matter is, my lord, one of his uncle was earlier allotted the pawn shop, my lord. Now, as inheritance, he asking for license.
Cannot be.
Power of
Kind of.
power of attorney.
Power of attorney is not transferable.
Text, my lord, text given by petition number 2, my lord.
The power of attorney is not transferable.
My lord, legal heir of petition number 1 and 2, my lord.
Legal error. Is a license transferable on the basis of legal error?
Government, my lord, allotted given, my lord, Surantanti, my lord.
License are not inheritable commodity. License is for the individual.
Lordship may dispose of directing the department to reconsider his prayer, my lord, after hearing him, my lord. His representation can be, my lord, disposed of.
You have filed your affidavit.
No, my
Affidavit,
lord,
no, instruction not.
no file affidavit, my lord.
But you don't have a, we don't find any right of yours which you can demonstrate. License you cannot get by inheritance.
No license, my lord, allotted plot of land, my lord, allotted.
Land can come. Allotted where is?
Demo block area, my lord.
Huh?
Demo block area, my lord.
Allotment is for a business, isn't it?
Yes, my lord.
Page, where is the order of allotment?
Allotment, my lord,
Page?
Annexer 1, page 16.
1/6.
Yes, my lord.
Let's see.
Cancel it.
Grant of permission to run a pawn shop.
Yes, my lord.
This is not allotment.
My lord, the
And-
subject was, my lord,
Yes.
as because he was handicapped, that is why the shop was allotted to him.
Yes. What is your right? This was given to your uncle because of his condition. How do you claim a right?
My lord, represented, my lord, to government, my lord, and paying receipt, my lord, Annexer 5, my lord.
Those are okay, but what is your right?
My lord, power of attorney, my lord, represented, my lord.
Uncle is there or not now?
No, my lord.
He's passed away.
First,
Then the entire condition goes.
Yes.
No, you don't have a case. Sorry. What is your name?
N. Roman.
Heard Sri N. Raman, learned counsel for the petitioner. Also heard Sri. Who are they? As Dr. Standing Counsel PNRD.
For all the respondents.
For all the respondents. Para. Considering the subject matter. Comma. This writ petition which is pending since the year 2022 is taken up for disposal at the admission stage. Please have your sit. Para. As per the facts projected the petition number 1. And the petitioners are father and son. Full stop. An order was passed on 21/9/1992 allowing one Sri Suren Tati to run a pawn shop, pawn shop, as he was physically challenged. Full stop. The petitioners had made a representation on 4/6/2022 for transferring the estates of as his legal heir. When did your uncle pass away? Legal heir. Legal heir, full stop. It is also averred that all the fee and revenue were paid up to date. Full stop. However, by the impute notice dated 28/7/2022, the pawn shop was directed to be handed over to the respondent authorities. Full stop. Para. 3. Rahman, the learned counsel has submitted that during the lifetime of the sage Suren Tati, the petitioners had taken care of the shop, and therefore, as a matter of inheritance, the representation should have been considered, and accordingly, the impugned action is unsustainable in law. Para. 3. Dr. Dilanis Standing Council has, however, submitted that the allotment orders itself would show that the same was made on peculiar facts and circumstances and cannot be a matter of inheritance. Para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Para. A cursory glance of the allotment order dated 21/9/1992 would show that the demo development block, that the BDO, the demo development block had given permission to run the pawn shop to the sage Sri Suren Tati, keeping in view his physical disability. Full stop. It is not in dispute that the said incumbent had passed away, and the present petitioners claim to be his brother and nephew. Full stop. In the considered opinion of this court, permission of the present nature cannot be treated to be inheritable in any manner, as the same was given to the incumbent, taking into consideration his physical disability. Full stop. This court is of the view that the impugned order dated 28/7/2022 does not suffer from any infirmity. Full stop. The writ petition accordingly stands dismissed, and the interim order passed earlier stands vacated. Full stop. Para. It is, however, made clear that if the petitioner makes any application for permission to run any business, the same would be considered on its own merits along with similarly situated persons.
Hello.
Your Lordship, no affidavit has yet been filed.
Matter
Matter pertains to Lordship, the private respondents have used the legacy data of my father to get their names into the NRC Lordship. So the verification has also been conducted. It was found that my claim is genuine. The private respondent number 8 has also been convicted for using false document.
Now, what is your relief? What is the relief you are seeking?
Lordship, I'm seeking that his name should be removed from the NRC to the extent he has used the name of my father to get into the.
Yes, why don't you do?
I'll get the.
Get instructions. Who was get some? Will you appear for the NRC?
No, Malad, 356.
Who's appear for the? Who'd appear for the NRC?
CFP is there, Lordship.
You can have Mr. Payang or Mr. G. Sharma, anyone.
Yes, yes.
Please call him. We'll give some instructions. These matters should not be kept pending. After a while. Try to bring either Mr. Payang or Mr. Sharma, okay?
May it please allow. Well, Your Lordship may look into the last order now. The government was to bring some instruction and the private respondent.
Yes, you have done. Private respondents?
My lord, I could not file the affidavit because my client is out of station for his treatment.
When can you do so?
First week of January, my lord.
First week of?
January. Just two things I have my copy.
Well,
Just
bring it
file
on
it
record. Bring it on
notification.
record. Well, these are controversial aspects. We have
Yes.
dealt with this matter.
My lord.
Yes.
Okay. Hartspreet P.K. Roy Chaudhary, learned counsel for the petitioners, who has drawn the attention of this court to the order dated 17/11/2025, requiring the private respondents to file affidavits. Para? Three, Dhar, the learned counsel for respondent number five submits that due to some unavoidable circumstance, comma, the affidavit could not be filed, which however would be done shortly, full stop. As paid for, list this matter in the first week of January 2026, by which time the affidavit is required to be filed.
No, the government also has to bring some instructions.
Instructions.
On the next date, comma, Sri, Miss, your department, Miss J. Hazarika, learned counsel for the Revenue Department, shall also obtain the instructions.
The interim order to continue this.
There are interim order passed earlier to continue till the next date of listing.
Published.
I'm with the respondent bank, Lordship.
You're for the respondent, yes.
My lords, this case pertains to the blanket freezing of my bank account. My
Mhm.
lords, the respondent, the blanket, they've placed a debit freeze on my bank account. My lords, they've filed an affidavit wherein the disputed amount is rupees 17,040. But my lords, the current balance that is there is 12,30,514. Now, my lords, there are different judgments of various high court which have stated that only the lien amount is to be kept as a lien and the rest of the money is to be.
Yes, what do you say, Mr. Nalvi?
To us, the several fraudulent transaction lordships, cyber crimes. We have received FIR.
You're for
of-
the SBI,
No, Bank of Maharashtra.
Bank of Maharashtra, okay.
So as per our, this one, the total amount is 20,176 as of now. As of now, it is 20,176. That is the amount. We have annexed the complaint and all these things. And some Bitcoin trade and all these things he has been doing. So I leave it to your lordship because he has admitted that he has been doing Bitcoin trades, POP and all these things he has been doing. That is an admitted fact.
No, those per se are not illegal.
No, I mean, because those ports are not illegal, but there has been.
But there is a
complaint-
cyber crime involved
Cyber crime is
involving
involved.
say 80,000 as per your.
Yeah, we have given the calculation also.
Page 83.
We have given the all the complaints we have received and all these things. So may I, because we have been receiving complaints out of the 1 lakh may be kept in lien and rust. He can.
Now, why 1 lakh? The amount quantified will be kept in lien and he'll give a bond. We'll direct him to keep a bond. It cannot be, first his involvement will not.
Because we have been receiving complaints after complaints. It is a continuous
On
process. That's-
speculation, how much amount? It
That
may
is
be
why-
1 lakh, it may be 2 lakh.
That is why I am not saying 2 lakhs. My entrepreneur also has agreed 1 lakh. That is what, for a period of 6 months, lordship. I don't mean to say for the entire year, for a period of 6 months.
My lord, in
And a bond.
January 2025, this account has been frozen. And so far they received all the complaints that they had to receive, they received.
Okay, we'll have a via media kind of a thing. 1 lakh will be on lien and you will also give a bond. And this lien will be for 6 months. After that, the freezing of 1 lakh would also.
Very
be.
good, very good.
Okay. Heard.
After that.
But you have a dangerous name, Mr. Mitra.
After that, the
What
lien
what
amount,
does the name, what does the name suggest? Name of the petitioner?
that my learned friend will say.
My lord, that's just a trading name, my lord. He's the proprietor of this, he's the proprietor of this.
But it might mean have a different meaning. What is the name?
My lord, Nepali meat cutting shop.
Not Nepali meat cutting. Nepali cutting,
Nepali cutting.
not Nepali meat cutting. Nepali cutting meat shop. It will be very dangerous.
It is tasty.
We are not under suspect. Whom are you cutting? To change your name.
That was my client, my lord.
Heard. This is item number
27.
Sri S. Mitra, Learned Counsel for the petitioner. Full stop. Also heard Sri K.K. Nandi for the respondent was 1, 2, and 3. CGC is a party here.
Yes, my lord.
Anyone CGC? And as well as RDB for the Learned CGC. Full stop. Para. Considering the facts and circumstances involved and also as agreed to by the Learned Counsel for the parties, comma, the instant writ petition is taken up for disposal at the admission stage. Full stop. Para. Please have your seat. As per the facts projected, the petitioner is a micro enterprise and is engaged in selling of meat at their place of business at Maligaon. Full stop. In connection with the said business, comma, the petitioner maintains a current bank account being account number so and so, which the Bank of Maharashtra Maligaon branch, which is under operation since October 2024. Full stop. It is averred that there is a credit of more than rupees 12 lakhs. Full stop. However, since January 2025, comma, debit transactions were stopped and on inquiry, comma, the petitioner was informed that the account was frozen upon a complaint received from the, what is NCCP-RP?
My lord, National Cybercrime Reporting Portal.
National Cyber Crimes Reporting Portal within bracket NCC-RP. Full stop. The petitioner had submitted a representation followed by a complaint to the banking ombudsman, which was rejected via an email dated 28/3/2025. Full stop. Assailing the said action, Sri Mitra, the learned counsel, has submitted that the petitioner is running a legal business and there is no fraudulent transaction of any nature in the related to the aforesaid bank account. Full stop. He has submitted that the action has been taken without any notice and information and has caused immense prejudice to the petitioner. Full stop. He has submitted that from the affidavit filed by the respondent numbers 1, 2, and 3, it transpires that an amount of rupees 12,000.
My lord, 17,040 rupees.
17,040 appears to be a part of a fraudulent transaction involving the present account. Full stop. In this regard, he has submitted that in similarly situated matters, there has been direction for keeping in lien the disputed amount and allowing the incumbents to run their respective bank accounts. Full stop. Today, the learned counsel for the contesting respondent numbers 1, 2, 1, 2, 2, 3 has submitted that the action taken is strictly in accordance with law and as per the direction of the NCC. He has submitted that at this stage it is not known regarding the magnitude of the fraudulent transaction which may be involved, in which this account may be involved, and the amount quantified may not be quantified at this stage, may not be the final amount. Full stop. Para now. He has also submitted that in the event this court grants any relief to the petitioner, some kind of protection be some kind of condition be imposed in the interest of public. Full stop. Para. After, where are the decisions?
My lord.
Have you enclosed? No.
My lord.
Have you enclosed anywhere?
No, my lord. I'll submit it now. My lord, the first is of the Delhi High Court, the Honorable Delhi High Court. The second is of
In this connection, he has referred to the following decisions. Full stop. Full stop. After consideration of the rival submissions, it transpires that the impugned action for freezing the bank account of the petitioner has been done on a complaint received by the respondent numbers 1, 2, and 3 from the NCC-RP. Full stop. A perusal of the affidavit in opposition filed by the said respondent numbers 1, 2, and 3 on 17/7/2025 would indicate that the amount involved is rupees 17, how much?
17,040 rupees, my lord.
17,000.
It is 20,170.
17,040. Full stop. Para. At this stage, comma, Sri Nandi, the learned council has clarified that the amount would be rupees 20,040.
20,176.
20,176. Full stop. While the learned counsel for the petitioner may be correct in contending that there cannot be a restriction on the use or restriction on the operation of the account by keeping the disputed amount in lien, comma. This court also finds force in the contention advanced by Sri Nandi, the learned counsel for the bank, that at this stage it may be difficult to quantify the amount involved and also the aspect as to whether there is involvement of the petitioner in the cybercrime. After giving an anxious thought to the rival contention, comma, this court is of the opinion that the equities would be balanced and interest of justice would be served if the bank account in question is directed to be, if a direction is given to allow the petitioner to operate the aforesaid bank account with certain conditions, full stop. This court accordingly directs that while the petitioner would be allowed to operate the account, comma, an amount of rupees 1 lakh be kept in lien till a period of 6 months. Full stop. If in this period of 6 months, comma, there is no material to link the petitioner either with the cyber offense or that any more amount is involved, comma, the aforesaid lien would cease to exist and the petitioner would be allowed to operate the account without any restriction, full stop. The petitioner is also required to give a bond that in case any material is found regarding its involvement after the period of 6 years, comma,
6 months.
6 months, 6 months, comma. No. What kind of bond he'll give? Tell us to secure.
He will indemnify the bank and its officers in all respects.
So as to indemnify for any loss which may be suffered by the bank. We'll reframe this. Petition stands allowed in the manner indicated above.
Much obliged.
Obliged.
Yes.
I mean,
You have to take instructions
my lord, I've
because
taken
he has made out a case. Some actions have been taken, but the final action has not been taken.
Yes.
When can you come up?
1 week, my lord.
We'll give you some more time. Next week it may not be possible because of the
Yes.
ensuing vacations. We'll have it immediately after the reopening, but you come up. Okay.
Yes.
Okay.
Extra copy, one extra copy.
Yes, he'll give the extra copy. This is item number
24.
Heard Sri S.J. Learned Counsel for the petitioner. Full stop. Considering the subject matter involved and after hearing the learned counsel for the petitioner, comma, this court has directed Sri J. Payang, learned standing counsel NRC, to obtain necessary instructions, including the action taken or proposed towards redressal of the grievance of the petitioner. Para. To facilitate Sri Payang, the learned standing counsel, to have the instructions, comma, let an extra copy be served upon him during the course of the day. Para. List for admission we'll have it on 8th of January.
My name may be shown, man.
Name of Sri J. Payang, Learner Standing Council, NRC, be reflected in the cause list. Much obliged.
Here, an affidavit in opposition.
My lord, we had filed the ADD opposition, my lord, but whatever, my lord, the copy was not shown to have been given to him, petitioner. It was addressed to the Lanka, GA Lanka Municipal Board and the government deputy. So we'll serve the copy by today, by tomorrow morning, and let him now prefer
What
time.
is
my
the
lord.
matter? You are the caveator.
Caveat.
What is the matter?
Matter about no confidence motion in Lanka Municipal Board, my lord.
In fact, pursuant to the no confidence motion, my lord, the motion was lost. Despite, my lord, the petitioner.
We can have day after tomorrow?
No, my lord, we need to respond to the counter affidavit, my lord. Sometime after vacation, my lord, it may be listed.
Vacation will be too long, but can it be fixed on 19, my lord?
They have filed the affidavit.
19,
Affidavit
18
filed, but
or
not served,
7.
copy not served to us.
No, they'll have a right to reply.
Yes, they have got the right. That's
But
why.
next week it may not be possible. Luck is in their favor.
Always luck is in our favor because our case is good, my lord.
No, case is not good, my lord. There I'll show.
You have an interim order also.
My lord, correct.
See?
Let it be, my lord, then, my lord. Second, third. Fourth or fifth. Fourth, fifth or sixth.
Of which year, which month?
January.
Fourth is Sunday.
Yes, fourth I know, it is Sunday, well, because up to 1 month I remember my date and days. So fourth is Sunday, so fifth is Monday, but
Fifth is reopening,
reopening, of course, my lord, but no, reopening is second, I think.
not second.
One is, 1 day is opening in between.
No.
No. Asa. Then I'll let you sixth.
Okay, sixth, okay. Sixth you file it,
My lord,
okay?
my lord.
Yes, and Matt will come and see.
Three, RP Sharma, London Senior Counsel for the respond number?
My lord, 6 to
10.
6 to 11, my
6
lord.
to 11
Right.
has submitted that though the affidavit in opposition has been filed, comma, due to some inadvertence, comma, the copy could not be served at the time of filing and which has however been done today. Done.
No, it will be done.
Oh, which will be done today. Will be. Good stuff. The
Because
SK
my-
Talukdar,
copy not
Learned
some-
Counsel
my-
for the petitioner prays for some time to file rejoinder affidavit. Para, since urgency has been expressed by Sri Sharma,
Yes.
the Learned Counsel for the respondents, private respondents, comma, let this matter be listed for admission on 6th of January 2026.
My lord, the
Interim order passed earlier to continue till the next date of listing.
Copy,
Right.
copy that in. I keep that.
Mail. This is regarding NOC, issuance of NOC for sale of land between two inter-religious communities.
Yes, so what is the?
My lord, in the meantime, my lord, they have rejected my application, my lord, so it become infructuous, my lord. Rejected on the ground that.
You can challenge the rejection order if you want.
No, my lord, on the ground that the tags are not matched, mismatched tag. So it infructuous, my lord.
What is your name?
K. Uddin, my lord.
Heard Sri K. Uddin, Learned Counsel for the petitioner. Also heard Revenue Department, Miss G. Hazarika, Learned Standing Counsel, Revenue Department, comma, Sri H. Sharma, Learned Additional Senior Advocate, Assam, and Sri Sensor. Para. Notice was issued in this case on 22/8/2025. Para. The cause of action was with regard to non-grant of NOC for sale of land, which was for an interreligious sale of land. Para. The Learned Counsel for the petitioner has, however, submitted that the application was considered and thereafter rejected as there were mismatch of the particulars of the land in question. Full stop. He accordingly submits that there may not be any live cause of action to be adjudicated in the present petition. Para. The aforesaid submission is not objected to by the learned counsel for the respondents, para. The writ petition is accordingly closed as infructuous.
The fresh application.
It is up to you. It is needless to state that the petitioners would be at liberty to file for fresh permission by giving the correct particulars.
Obliged.
Lordship, in this matter, affidavit will file me today.
Fine.
No, we are going to file today, my lord. Just now I have.
What is the matter, Mr. Amen?
Acquisition matter, land acquisition.
Okay, let them file the affidavit there.
It's ready. Today I will, during the course of the day.
Okay. Heard 3J Ahmed, learned counsel for the petitioner, para.
Next week.
Ms. M. Burman, learned state counsel has submitted that the affidavit in opposition would be filed during the course of the day
We have respondent number 5.
on behalf of the respondent number 5, course of the day. And in fact, such copy has already been submitted to the learned counsel for the petitioner. Full stop. Para, in view of the above, matter is adjourned to be listed after a week. By which time the affidavit that may be filed be brought on record.
That may be given next week.
Next week would be difficult. Next week all motion
After
day.
2 weeks.
Huh?
After 2 weeks, that may be given.
After 2 weeks in vacation.
10, my lord, 10.
Huh?
10 December.
10 January.
10 December, my lord.
10 December.
That
Oh,
would be
sorry,
Wednesday. Next week. Yes.
10 December is day after tomorrow.
Oh, no, no.
After vacation,
First, the third, fourth January.
list in the first week of January 2026. আগৰটো যে দেখিছিলো কিবা লিখিছিলো আগ লাইনটো আগৰ লাইনটো কি আছিলে 10 টাকা তাৰে আগৰ লাইনটো no, list in the first, I'll get to last line, no, list in the first week of January along with the copy of the affidavit. Okay. Next.
32 to 35 similar matters, my lord. We have received instructions, let it be after vacation, my lord. In the meantime. we will
Along
file
with
the
that.
response.
Along with the first, this
Similar matter.
Issue is similar, my lord.
31 is similar.
Similar,
Okay.
sir.
32 to so and so. You have filed affidavit there?
No, my lord. Instruction we have received
Then,
today, my lord.
And the others?
More time.
Heard Sri J. Ahmed, learned counsel for the petitioners. Sarah? Miss M. Burman, learned state counsel, have submitted that instructions have been received. Full stop. List after the vacation along with WPC 5554 of 2025. Okay?
Up to 35, so both are similar.
Eta order, 32 to 35. You are appearing for? DDAS is present for the APDC. In the first case, you are also appearing. Anybody else appearing? Madam Sharma, you are appearing. Public Works and Revenue, so what name likhi S. Sharma, Standing Council PWD, and G. Hazarika, Standing Council Revenue.
Obliged.
Okay. Yes, Madam Gogoi, what is this?
Petition filed this petition for filing, seeking permission to allow to file the statutory appeal, my lord. Because it is beyond
There is
time.
no such provision to, my lord, seek leave of the honorable court to prepare an appeal. What has happened is, my lord, the limitation.
You missed the bus.
You missed the bus, yes.
My lord,
Is there any aspect of condonation?
Condonation is, my lord, only for a
Yes.
period of 3 months or to the extent of 6 months. Thereafter, no, my lord. Now they wanted the honorable court to, my lord, interfere.
No,
It is a
the-
statute, my lord.
DRC 07 has been passed on 13th of.
But, my lord, my instruction I awaited, my lord. If they agree, my lord, I can place it. Let it be, my lord, immediately in January first week.
The statutory fees he is going to pay.
It will create a floodgate, my lord, of cases, my lord. You can't believe.
Madam, there are certain aspects where delay condonation is governed by the statute.
Yes.
Like the 34 of Arbitration Act.
Man.
It's a self-containing statute. It's, and these kind of things, there is no application of the Limitation Act.
Yes. Special acts, my lord.
And
No, this is not in a matter of a suit or an application. It's another authority.
Yes, already there in the circle.
5 will be applicable where? In application, appeals. This is different. Okay, you take instruction. We'll, okay.
Let it be on immediately after you.
Okay. Heard Miss N. Gogoi, learned counsel for the petitioner, para. Shri B. Gogoi, learned. You appear for the what?
All are responsible. My lord, state taxes.
Huh?
GST, state GST.
Learned standing counsel, state GST. Praise for some time to obtain instructions as to whether the appeal which the petitioners are proposing to file can be accepted. Full stop, para. List immediately after the winter vacation.
37 same, 36, 37 same.
date may be fixed, my lord. Can it be?
List on, when after the Bihu, before the Bihu.
Before the petition.
Before Bihu will be 9th.
How
9 January. Actually, order. Same subject matter is the same.
Assessment years are different.
Common order code it. It duita logaba de, or duta likhi duta te logaba karte. Item? Yes, Mr. Barwa?
Maybe it's not.
Yes, please.
But the matter, my lord, regarding my lord, establishment of brick lane mine industry. My lord, this is my lord, this continue in spite of the Supreme Appellate Court order, my lord. The matter was heard by different court various time, my lord, and once you wrote it, heard the matter also.
Is it?
Well, but the Supreme Court decision is there, my lord. On that count, the Supreme Court, if economic zone is not finalized, in that case, my lord, Kent Radius will be declared as a my lord, but there is no industrial activity. In that regard, my lord, last time, my lord, that forest, my lord, filed affidavit, my lord, they have said, my lord, there is no proposal for pending regarding, my lord, eco-centric zone, my lord. That means, my lord, that Supreme Court judgment is operated, my lord, 10 kilometers will be declared as eco-centric zone. There is no industrial activity. Even this, my lord, they are continuing, my lord.
Who is for the private respondent?
The Pora, BP Pora is.
Yes. What do you say? When can he come? After some time. Please wait for a while.
Yes.
May I please, your lordship? Lordship, this matter kindly be passed over for the time being, lordship.
I'm being.
Mr. PP Datta is on legs in court, another court, lordship.
I mean, Lord, in this case, I have been newly engaged, my lord, and I have filed Okalok on the 3rd.
For whom?
On 9/10, my lord.
9 and 10.
9 and 10.
And Hussein?
I am for the 8 and 11, lordship.
8 and 11.
Lordship.
Affidavit filed.
I have filed affidavit. He has filed. That is not.
Let them file the affidavit.
Last occasion, lordship, respondent number 8 to 11 was represented, lordship, by caveator, lordship.
Okay.
But they have taken NOC, 9 and 10. lordship.
New council has come. There is a division between the parties.
Lordship is aware what would be the tactics to delay the matter.
We are not aware.
Lordship has
We do not know anything.
Lordship has also shifted from this side to that
We
side.
do not know that they have all the rights to engage another council. NOC is there.
Yes, sir. But thing is that, lordship, the same council has filed a representation, same parties together.
Now,
Same party
they want
appeal-
to file the affidavit.
Same party.
Let them file the affidavit. We will confine them to some limited time. What is the issue involved?
Issue involved that, lordship, the first meeting, 6 members were present out of 10. His contention is that the 1/3 member, if not present, that it will have to be deferred. For quorum, lordship, 1/3 is must.
Out of 10, 6 were present. His contention is that as 1/3 was not present, so there is no quorum.
No.
Totally absurd
But-
submission, the matter is delaying, and the.
How can that be the contention? If 6 are present, quorum is there.
No, my lord.
No.
As per 46(3), my lord. As per 46(3) is different, my
We
lord. While
have
110
interpreted
contention
this.
is that
That can-
18(3),
that-
18(1).
That cannot be the interpretation. We have interpreted this.
Yes, I may be allowed to twist time to file.
Not necessarily.
These are questions of law. How will you improve your case?
Yes, my lord, I will improve my.
Calculation. Let us read the statute and finish this off.
Lordship, section 18 will come only after taking oath, Lordship.
I'm not on
For the
18. I'm on 46(3) only.
46.
Let us see 46.
46(3) only, Lord.
Oh.
Lordship got it?
Yes.
Lordship 46.
Hmm.
Election of president and vice president of Gaon Panchayat. The deputy commissioner or the subdivisional officer, as the case may be, shall call the first meeting of a Gaon Panchayat under clause B of subsection 1 of section 6 of the Act by fixing a date and by causing a written notice specifying the date, time and place and so on. Now let us come to direct 3, Lordship. If 1/3 or more of the total number of members called to the meeting under Sub-Rule 1 are not present within an hour of the time fixed for the meeting, the deputy commissioner or the subdivisional commissioner, as the case may be, or the officer empowered in this behalf, shall adjourn the meeting pending fixation of another date by the deputy commissioner or the subdivisional officer, as the case may be, not later than 15 days of such meeting. His contention is that as 1/3 member, the 4 member were not.
No, what about this thing? Who has taken the decision? Sharma?
The deputy commissioner.
Yes.
And deputy commissioner
What do
directed
you
police
say?
record.
If it is 1/3, then petitioner has a case. If it is 2/3, then he doesn't have a case. This is the.
Now,
This
on
is the
record
proceeding law.
says how many present? 6.
6, yes.
Then
Yes, you
you cannot give a reverse meaning to this.
That cannot be.
Only 1/3 when it is present.
Only 1/3 cannot be.
That is not the meaning.
And because of this interim order passed by this honorable.
Okay, we dispose of.
Lots.
Lordship.
My lord, in this issue, my lord, 46(3), coordinate.
There is a status quo order.
Status quo order not to hold meeting.
Okay.
The thing is that constitutional mandate.
Yes, what is
My lord, in this connection, regarding 46(3), my lord, a coordinate bench already decided in my case, my lord. Yes. Something there. Okay.
I think while passing the interim order, we have quoted all this.
Lordship.
We remember this.
And taking the sanction
Yes,
in
yes,
same order, the deputy commissioner has passed the order even without hearing me. There is also that another ground of challenge.
WBC 4505 2022, Lordship.
Give-
Disposal.
Already disposal.
Oh, you have to give, not saying you will not do. Where is the order? Suddenly you say something.
Yes, I am giving the.
And we find that is an order passed in a
Okay.
compassionate appointment case.
That's why I may be allowed to twist time to file.
You are not prepared, you are not prepared. This is a question of law. It's not going to change any or, okay.
Already decided, my lord. 46(3), my lord.
You have to place it before us.
Yes, my lord, I am placing.
Place it now.
WC 4505, Lordship, 2025, Lordship.
You can say many things, mister. Is this how you assist a court?
Sorry.
At 2 PM, my lord.
Okay, 2 o'clock.
God bless.
There should be some limit of the playing tactics with the court, Lordship. It is not fair, Lordship.
Yes, Mr. Bora?
Here forest and file an affidavit. The court has asked whether some proposals were pending or not. Before now, whether it was, the affidavit is not clear as whether some proposals were initially sent to the ministry or not. What has happened, the proposal was initially sent to the ministry for some modifications. I think it is sent back from the ministry. Now, Lordship, if Lordship allows me, then Lordship, a short reply,
Reply to whom? Forest?
Forest.
The case in the Supreme Court, there is no
And moreover, earlier, the benchmark was 10 kilometer, but after the 2023 judgment, it has become 1 kilometer, Lordship. And it is admitted my bricklane is at 1200 meters, Lordship.
That is my not.
Beyond 1 kilometer.
Beyond 1 kilometer. Secondly, there are another 8 to 10 bricklanes, but the petitioner is only agree if the locus he has assumed as an environmentalist, he should be aggrieved by any bricklane setup. There are adjacent bricklanes also there, but he is not questioned. Therefore, Lordship,
Mr. Bora, who are you?
No, we are the person having agricultural land around that my lord, clean, my lord. Because apart from my lord, they, well, if a weekly is continuing, my lord, affect our, my lord, land also, my lord. And well, the Supreme Court judgment has said, clearly state, my lord, if my lord, no proposal is, my lord, finalized, in that case, my lord, 10 kilometer radius, whether 1 kilometer, 2 kilometers.
Yes, Mr.
We have filed an affidavit, no proposal was sent, your lordship. There was a draft proposal, but it never was sent.
Proposal for?
Proposal for this eco-sensitive zone.
Okay.
There is no proposal, your lordship. You have taken category stand on affidavit, your lordship. There is no proposal.
So what will be the position if there is no
No
proposal?
proposal, 10 kilometer radius stands, your lordship.
Lordship, that thing also, Lordship, Lordship will hear that point because as per 56(10), it says that 10 kilometers as per order dated 4/6/2006 and the guidelines. Now, the 4/6/2006 order has been subsequently modified in 2014 and 2022. Now, that then modification has also been done to 1 kilometer. Therefore, this point also, Lordship would some
What do you say
consideration.
on this, Mr. Gogoi? Has it been reduced? The 10 kilometers, has it been reduced to 1
If there is a
kilometer?
proposal sent,
Or if no proposal,
no proposal, 10 kilometers stands.
how do you overcome this, Mr. Bora?
Yes,
Difficult.
Lordship, that judgment of 22 says that 10 kilometer as per order dated 4/12/2006. Now the order dated 4/12/2006 has already been modified.
But there is no proposal sent. If proposal is not sent, where is the modification?
Therefore, Lordship will keep that, Lordship will hear this matter. I'll address on this issue.
Address it today.
Same thing, my lord, if you permit me, my lord, take on to
Lordship, what has happened actually, I have sent somebody to bring the file, so mistakenly some other file has come. So I have already sent, Lordship takes up two, Lordship. That is the, I mean.
A clear case, my lord, 10 kilometers.
No, and
he doesn't have the file.
Modification, my lord, why, my lord?
No, and moreover, there is no pleadings that the petitioners have some agriculture. There is no pleadings.
I'm stated, my lord. 226 petition, my lord.
No, Lordship, infringements of their right, Lordship. We say 226, not a PI, Lordship. Read petition, Lordship.
Okay, we'll have it day after tomorrow. We bring your file day after tomorrow.
Specific pleadings of that.
Day after tomorrow.
Tell me what, Thursday, my lord.
Huh?
Thursday.
Thursday. 11th.
If not, well, if
11th
or next Tuesday, Lordship.
Next week it will be difficult. Next week there will be motion matters.
11, my lord.
11, okay. Heard Sri R. Barua, learned counsel for the petitioners, Sarah. Also heard Sri R. Gugoi, learned standing counsel Forest Department, comma. Sri H. Sharma, learned additional senior advocate, and Ms. G. Bora, learned counsel for the Agriculture Department. Sarah. Sri, last of N. Sri, BP Bora, last of N. BP Bora, learned counsel for respondent number 12. Para, on the prayer of Sri Bora, Sri G. BP Bora, learned counsel for respondent number 12. Matter is adjourned to be listed on 11th. Deep blue. Thirty-nine contempt, what is this? Who's for? Where is the new counsel for the alleged contemners? None appears for the parties on call. Para, in the interest of justice, matter is adjourned to be listed on Wednesday, full stop. It is made clear that in case of further non-representation, comma, this court would pass appropriate orders. Next. Yes, Mr. Vishwas?
Yes, this is directed against the willful disobedience on the part of the.
Appeared. You have appeared.
Notice is yet to be issued, my lord. On honorable court's direction, I send the instruction and last order also, but till date, I have not received any instruction, my lord. After the order dated.
Let us issue notice. Why should
Yes,
not
yes.
24 matter contempt notice
Yes.
should not be issued?
And he is not responding as yet.
What is
my lord.
going on, your lordship? The circle officer, in spite of the specific direction that 2 boundary dispute cases should be taken up.
This incumbents are still there, Mr. Vishwas?
Yes, yes.
Yes. And a latest direction has been received by us, whereby the
Okay.
demarcation is going to
Three
be
A,
take
Vishwas,
place on
learned
11.
counsel for the petitioner, who by means of this application has alleged willful and deliberate disobedience of an order dated 7/8/2024 passed in WPC 2097 of 2022. Full stop. Sri Vishwas, the learned counsel, has also drawn the attention of this court to the where is the representation?
Representation we had submitted before them on
Where?
11/2/25. Your Lordship.
Where?
Before the circle officer.
Where is this petition? Are they aware that this order has been passed officially? This is something basic, Mr. Biswas. If you do not do, how can you issue notice?
No. The thing is, after this initial order, we appeared only in only one of the demarcation. We repeatedly been asking for the second demarcation that 61 is there. They are not proceeding with 61, they are only proceeding with this. And in fact, in the latest order, they have fixed 11/12 for the actual demarcation. At the bottom, it is there, the lot mandal, etc. have been directed to submit the report on.
Where have you stated?
We have received it yesterday. Your
No, where have you stated in the petition that you have appeared and no action?
No,
taken?
this was done before because after this honorable court directed on the last order, your lordship was pleased to pass an order on 2/12/24. 2
So these orders were passed without notice.
Yes.
Can we bind them?
We cannot bind them.
Have to follow some procedure.
Yes, Your Lordship.
Notice has to be served upon them. And this is a contempt, you have to notify them that this is an order you have to comply with.
Yes,
Have you stated anywhere that you had appeared before them in terms of the order,
in that,
in the contempt
Yes.
petition? Where have you stated?
we para 5 in page 9, Your Lordship. That the petitioner begs to state that pursuant to the passing of the order dated such and such, the petitioner on 21/9/24 filed an objection. including-
By drawing the attention of this court to the averments made in paragraph 5 of the petition, the learned counsel has submitted that the petitioner had appeared on 21/9/2024 and filed an objection. Full stop. However, till date, the orders of this court have not been complied with. Para. That notice be issued, returnable by 4 weeks. Let steps be taken by Speed per Speed AD within 2 working days. Let it be formally.
Yes, sir.
Let them appear.
Highly obliged.
In that manner, my lord, that my name may not be reflected, madam, if they engage some new counsel, because they are not cooperating with
The
me.
name of Ms.
I'm
M.
not
Burman,
appearing.
learned counsel is not required to be reflected in the cause list.
Obliged.
Forty-one, MSA.
Apologize, Lordship, with regard to item 39. Apologize, Lordship, I missed it. I appear for the respondent number 3,
39, day after tomorrow, come prepared.
Lordship.
41. There is no representation on behalf of the petitioner. Are you for what? On behalf of the applicant. The application has been filed for correction oblique modification of an earlier order para in the interest of justice. Matter is adjourned to be listed immediately after the winter vacation. Muslim on Thursday, on Friday next. There will be urgency. Thursday next, Friday next. Date to delete. Next. Yes, Mr. Chakraborty.
For a little correction, Malad, page 13.
1-3.
Yes, Malad, para 11.
Yes.
Shilling case number 225, Malad, to be inserted.
Yes, madam.
No.
Second line, Malad.
Oh, second case 222. It should be 225 of?
1982, Malad.
Oh.
Well, year may not be given, only 225.
Okay. Oh. Third, Sri R. Chakraborty, learned counsel for the applicant who by means of this application has prayed for correction of a typographical error which crept in the order dated 22/10/25 passed
Yes,
in the
ma'am.
connected WPC 7631 of 2018, full stop. By drawing the attention of this court to paragraph 11 of the said judgment, the learned counsel for the applicant has submitted that the number of the sealing case should have been sealing case 225 instead of sealing case 2025. Para? Ms. M. Burman, learned state counsel does not object to the aforesaid prayer for correction, full stop. Para. After hearing the learned counsel for the parties and on perusal of the materials on record, it appears that while that in the aforesaid judgment, there is an inadvertent error insofar as giving the number of the sealing case, full stop. It is accordingly directed that sealing case 2025 appearing in paragraph 11 should be read as sealing case 225. Para, I accordingly stands allowed. Let this order be be read as a part of the order dated so and so, past the
22.
WPC so and so.
All right.
I dispose of. Yes, please.
May I please, Your Lordship?
Yes, what is this?
Lordship, in the writ petition, Your Lordship, we have telling
IFR?
I is for Your Lordship, in the meanwhile, during pendency of the writ petition, Your Lordship, Your Lordship may kindly come to page 21, Your Lordship. An letter was issued by the Finance Taxation Department, Your Lordship, to the Excise Department, Your Lordship. May I read-
Yes, what do you say, Mr. Both of you are there?
This is implementation.
This is for implement already allotted earlier.
This is not implementation, this is for, I think, you're praying for.
My
state.
prayer is that, Your Lordship, we should not be, for our renewal of licenses, Your Lordship.
He is
the-
praying for an interim order.
He's
Yes.
praying for interim order, Your Lordship. We'll take instruction on this. In the morning, there was another similar matter was here, Lordship. This matter has been taken with this together, Your Lordship. Item number most probably.
Retrospective effect.
Lordship.
Retrospective effect. to the
Yes,
VAT.
yes.
That, Your Lordship has already issued notice in my case, Your
Yeah.
Lordship. And here, Your Lordship, we are concerned with that, Your Lordship. They are saying that.
Okay, you take instruction, we'll have day after tomorrow.
Lordship.
Friday, Your Lordship.
Friday, okay, Friday. Third, 3 as Botakur learned counsel for the applicant who by means of this application is praying for certain interim orders. Para? Both 3 are Gogoi learned standing counsel excise department and Sri B Gogoi learned standing counsel state learned standing excise GST. Pray for some time. Para? List on Friday.
Lordship.
Please give the date to enable the learned counsel to obtain the instructions.
Our name may be reflected in the causes, Your Lordship.
Names of 3 R Gogoi and 3 B Gogoi standing counsel be reflected in the court list.
Deeply obliged.
Yes, Mr. Das.
My lord, in this case, my lord, petitioners on elected member of the Gaon Panchayat, my lord. Yes. A letter issued, my lord, part of.
Lordship, we have not received any instructions. May I pray for some time?
Oath taking has been not allowed, my lord. Oath taking program, my lord, meeting. It was issued, my lord, 3rd of December and meeting held, my lord, for 12th, my lord.
The private respondents have been served. We can have this for admission. When?
After the vacation.
Heard 3 H. Das learned counsel for the petitioner. Full stop. Peruse the order dated 5/12/2025 passed by the learned Lazima court, as per which the service upon the spot numbers 6, 7, 8, 9, and 10 are held to be served. Full stop. The said report is accepted. List for admission hearing.
Before vacation, my lord, any date.
Before
Because my
vacation,
lord, oath
it may
taking
not
has
come.
not allowed, my lord.
May not come,
Oath
Lord.
taking meeting, just my prayers only.
Okay, we'll try this Friday, then if not,
Yes.
then after the weekend. Next week it might be possible, okay? On Friday.
Obliged, my lord, highly obliged.
Okay, that's enough. Mr. Chaudhary, which matter is your?
I think 55 minutes.
If you want, you can do it now. If it doesn't take time, we will not.
55 also, Lordship, we have not received any instructions, though
No, my lord,
pendency shall not be a bar.
My lord, no. We have filed an IA, my lord. It's a very serious matter, my lord. The petitioner, he has impersonated himself. Because if your lordship would kindly take IA 3859, my lord, it's a very serious matter. Now, they allege that my higher secondary mark sheet was.
What is your client's name?
Mine is, my lord.
Mamun
is
Shah.
the petitioner.
No, what is your client's name?
Mamun Shah is the applicant.
Is the respondent in the? Okay.
7.
Okay.
Now, my lord, he claimed he has filed the petition as Abdul Munab Sheikh. Whereas the papers, when he submitted for my lord, while submitting his nomination, his name is Abdul Munab Talukdar. And the pass certificate, higher secondary pass certificate is also Talukdar, which have annexed. Kindly see, my lord, page 28 of the IA. page 26 and 28.
Now we have to know the subject matter.
Yes.
Okay, we'll take it up at 2 o'clock. It might take some time. Here for Mounta for
the
repetition. At 2 o'clock we'll come.
2 o'clock.
Your application is for modification.
Yes.
Stay vacation. Deeply.
Yes.
Lordship, issue is very limited and simple, Lordship. Before going to that portion, Lordship.
Tell us the facts
Yes.
in
Lordship.
nutshell.
Yes, Lordship, petitioner was the elected member of Ward number 9 of Hiladharimukh Gaon Panchayat under Bishwanath Ferry.
Of Panchayat?
Panchayat, Lordship, Gaon Panchayat. Lordship.
Of ward number?
Ward number 9.
Okay.
And as per of section 6 of that Assam Panchayat Act, the constitution of
Yes.
Constitution of Gaon Panchayat and election of president and vice president has been governed under section 6 of the Assam Panchayat Act.
Yes.
As per section 6, that Gaon Panchayat consists with 10 members of directly elected ward members. As per 6(1). And Lordship, election of president and vice president is an indirect election, was elected by the members who has been directly elected. And as per section 3, Lordship, of section 6, district commissioner or an officer authorized by district commissioner shall call for a meeting of the Gaon Panchayat for election of president and Bhau Panchayat. And the district commissioner shall preside over a meeting in the manner prescribed. That manner has been given in Rule 46 of the Assam Panchayat Constitutional Rule, Lordship, which Lordship would find in that book, Lordship, page 213.
The president is elected amongst the as 10 members.
10 members, Lordship.
Not directly by the.
Not directly. But it was amended now, Lordship. Earlier it was directly. elected.
Earlier it was directly.
Directly. elected.
Yes. Now this
Now
speaks of the Assam Panchayat Act.
Assam Panchayat Act. Lordship.
Oh, okay.
Now, under that, as per section 3, Lordship, that deputy commissioner or his authorized shall call for a meeting of the Gaon Panchayat, which shall be the first meeting. That Lordship would find page 34 of my writ petition, the proceeding of the first meeting.
Page?
Page 34, Annex 4 of my writ petition, Lordship.
Yes.
As per that, Lordship, meeting, that page 35, Lordship, may I read, Lordship?
Yes.
Very brief. Today, that is on 27th.
This is the minutes.
Minutes, Lordship.
Yes.
Today on so-and-so, the first meeting and oath-taking ceremony of newly elected member of the Hiladharimukh Gaon Panchayat was held in the conference of the Bishwanath Development Block. Today's meeting was presided by the Block Development Officer of the Bishwanath Development Block. Executive Magistrate Sir as authorized officer and secretary were present in the today's meeting. Firstly, the meeting started with an introduction of newly elected members. the ward member gave their self-introduction in the meeting. After introduction session, the members present today for the oath-taking ceremony were felicitated with a Fulam Gamucha. After felicitation, respected executive magistrate authorized by the government of Assam who is present in the oath-taking ceremony delivered his speech. Executive magistrate sir read the oath for the oath-taking ceremony to the newly elected members of the Giladhari Mukh Gaon Panchayat. The members present in the today's meeting and their ward are these 6 members were present out of 10. That by resolution number, first resolution, page 36, Lordship would find. That
What is your name? Burhan Ali?
Mine Burhan Ali. That Burhan Ali was elected as a president, Lordship.
Petitioner.
Petitioner.
Okay.
And the vice president, by resolution number 2, Vice President Mofida Khatun was elected as a vice president.
Okay.
And Lordship, page 40, Annexure 5, Lordship. This is the election of that petitioner and that Mofida Khatun, Lordship. Page 40, Annexure 5 is relating to the election of petitioner, and page 41, election of Vice President Mofida Khatun. Thereafter, Lordship, Annexure 7, page 44, they have submitted one application before the District Commissioner.
Forty?
44, Lordship. Lordship, this is application under section 11 of the Assam Panchayat Act. Their contention in the second paragraph, Lordship. The first meeting dated so-and-so was attended by only 6 elected ward members out of 10. The ward member of ward number 4, 5, 6, 8, 9 and 10 attended the first meeting held on so-and-so. The quorum for the first meeting of elected ward member of Gaon Panchayat is 7. Therefore, the meeting was held without quorum and total violation of provision of 46(3) of the Assam Panchayat Act. Under the above facts, under the above facts and circumstances as well as by operation of law, the resolution, oath and election and selection of president and vice president in the first meeting that is so-and-so are known as in the eye of law. Therefore, first meeting of elected ward members is required to be held by following due process by statutory mandate. After that Lordship application, they have moved before this honorable court by way of writ petition number 3954/2025, page 47. This honorable court has passed an interim order. Notice issued, and one observation was made that pendency of a writ petition shall not be a bar to decide the application filed under section 11. Page 47. Operative portion, Lordship would find page 51. Lordship, second paragraph. It has been alleged on behalf of the petitioner that quorum was not followed in the said election. Lordship, got it? Shri Hussain, learned counsel for the petitioners, has also submitted that an application in accordance with law section 11 of the Assam Panchayat has been filed, which is however has not been acted upon. Lordship has issued notice, and in second paragraph, page 52, next page, pendency of this petition shall not be a bar for the respondent for consideration and disposal of the representation said to have been filed before the district magistrate, respond number 3. Thereafter, Lordship, after receiving that page 53, that impugn order dated 10th September 2025 has been passed by the District Commissioner. Lordship, may I read, Lordship? This is a very
53.
53. Subject, cancellation of the first meeting held.
What is the date? 10 September.
10 September, Lordship. Cancellation of the first meeting held on 27 June for oath taking and election of president and vice president of 14 number Giladhari Mukh Gaon Panchayat. Whereas a complaint petition was submitted by Digonto Hoikia and Samsul Islam alleging procedural irregularities in connection with the first meeting convened on so-and-so held for the oath taking and election of the president and vice president of 14 number Giladhari Mukh Gaon Panchayat under Bishwanath Development Block. And whereas this office by the order number so-and-so 29 June so-and-so has notified the said meeting, and whereas pursuant to the interim order passed by this Honorable Guwahati High Court in WPC number so-and-so, and upon perusal of the report submitted by the Chief Executive Officer, Jila Porikhot, Bishwanath, and the Block Development Officer, Bishwanath Development Block, it has been found that said meeting was held without required quorum in contravention with Rule 46(3) of the Assam Panchayat Constitution Rule 1995. Now, therefore, in exercise of power conferred upon me under Section 11 of the Assam Panchayat Act, I, the District Commissioner Bishwanath, do hereby declare meeting held on so-and-so as cancelled. A fresh date for the meeting for oath-taking election of president will be notified later on. Thereafter, Lordship, page 54, Annexure 10, that writ petition was withdrawn by the respondents hearing that petitioners. And petition was closed as in fact was. Against that order of impugn order, Lordship, cancellation of election of petitioner and the oath taking ceremony, I am before your Lordship primarily on two grounds, Lordship. First, that there is total non-application of mine on the part of the District Commissioner. Taking the recourse of this order, arms with this order has illegally passed this order. First thing, Lordship, there is a total violation of naturalization and there is an erroneous interpretation of the law laid down under Section 46(3) of the Assam Panchayat Constitutional Rule 1995, Lordship. If for the moment, Lordship, if I draw your attention to the Rule 46(6) of the Assam Panchayat Constitution Rule 1995. Their basic contention, if 1/3 member is not present, that meeting has to be deferred. The 46, Lordship, got it, page 213, Lordship, it got.
Yes.
46(1), the Deputy Commissioner or the Sub-Divisional Officer, as the case may be, shall call the first meeting of the Gaon Panchayat under Clause B of subsection 1 of Section 6 of this Act by fixing a date by causing a written notice specifying the date, time, and place mentioning to be served on the elected member of a Gaon Panchayat concerned at least 7 days before the date so fixed. Such meeting shall be presided over by an authorized officer authorized by the Deputy Commissioner or the Sub-Divisional Officer, as the case may be. 2. The officer authorized in subsection 1 shall administer the oath of affirmation to the member of the Gaon Panchayat under Section 134 of the Act. 3. If 1/3 or more of the total number of members called to the meeting under Schedule 1 are not present within an hour of the time fixed for the meeting, the Deputy Commissioner or the Sub-Divisional Commissioner, as the case may be, or the officer empowered in this behalf, shall adjourn the meeting pending fixation of another date by the Deputy Commissioner or the Sub-Divisional Officer, as the case may be, not later than 15 days of such meeting.
Yes.
Now we are entire argument and dispute adjudication is zeroed down to that subclause 3 of Rule 43. As per my humble understanding before this Honorable Court, this interpretation, if we have to give the interpretation of plain reading of this interpretation, we will have to adopt those interpretations which should facilitate the true import and intent of the legislature. The legislature intention of incorporating Section 46(3) is to constitute the election of the panchayat and to hold the election, not to frustrate, not to hold the election, Lordship. If we give an interpretation that adopt the interpretation of the respondent, that if 1/3 or more is not present, it has to be deferred. Yet it will have to be deferred day and day that the entire purpose and important intention of the legislature will be frustrated. That interpretation is, in my humble submission, is an incorrect and erroneous submission, which is adopted by the District Commissioner. So for that count, Lordship, this impugn order has to go, Lordship. Second limb of argument is that before issuing that order, even no notice, no hearing was afforded to me. On these 2 points, Lordship, I am praying before your Lordship that impugn decision has to be set aside and the Panchayati Raj, constitutional provision of Panchayati Raj has to be restored in respect of that Ghiladhari Gaon Panchayat, Lordship. The public has been suffering, Lordship. This is my humble subject. And they have filed affidavit in opposition. They have not denied that fact, Lordship. Only they have tried to interpret the provision in the negative way, Lordship. If we give the, for my sake, Lordship, I will read once again. If 1/3 or more of the total members called for the meeting under Schedule 1 are not present, if I assume in the positive, if present, then what would be the consequence? If present, they must hold the meeting. This is my case, Lordship. And there are 6 members present.
How much is 1/3 of 10th?
4, Lordship. And there are 6 members present. He points something, but we cannot ignore that into the Lordship.
Yes, that's your case?
Yes, it.
Yes.
There are two allegations made by the petitioner's lordship. One is misinterpretation of the statute, another one is violation of natural justice. In the earlier set of writ petition, the order was pendency of this petition shall not be a bar for the respondents to consider and dispose of. Accordingly, the representation which was pending before the district commissioner was disposed of.
Yes.
By disposing of that representation, that order was passed according to the district commissioner that there was a lack of quorum. Secondly, Lordship, if we go by this 46(3), if 1/3 or more of the total number of members called to the meeting under sub-rule 1 are not present within an hour of the time fixed. So 1/3, here the total members are 10. Out of that, 6 members were present in the meeting. So accordingly, 1/3, that 4 member was present on that day in the meeting. And if we go by the another way, 1/3 of the members were not present. So that 1/3 means the 4 members were not present. But I think, Lordship, this the interpretation of the first argument, Lordship, that will be that 1/3 of the members were present on that day. And my learned friend is also relying upon a judgment order passed by this honorable court that I have gone through. There, the situation, there 4 members were present. And they so challenging that they have filed a representation before the district commissioner that was not disposed of. So this honorable court has directed the district commissioner to dispose of that representation by giving a proper hearing to both the parties. But there was no such finding regarding that. But my learned friend will be better for that.
In fact, in this case also, in the first round, which was instituted on their petition, the interim order observation was pendency shall not be a bar. In the same lines,
Lordship.
You said that there is some interpretation. That is not the interpretation.
That is the interpretation by them, Lordship. The same interpretation.
Not by the court. There is no binding precedent.
But even then, my learned friend will be better to place this case, Lordship. But regarding that violation of natural justice, Lordship, I deny that. As because that is he was directed to dispose of that representation, so it was disposed of.
It does not mean that by violating that.
You come to Mr. Ratna, not your chance. Yes.
My lord, I have very limited submission, Lordship. So
Put for whom?
I am for response number 8 and 11, Lordship.
Yes.
I have very limited submission that, Lordship, as per Rule 46(3), Lordship, if 1/3 or more of the total number of members called to the meeting are not present within an hour, not present means if they are absent, Lordship. That is my humble submission. If 4 are absent, Lordship, then meeting has to be adjourned, Lordship. This is my limited submission that interpretation part is concerned. And so for other part are concerned, Lordship, Six were present, that is admitted fact, Lordship. Proceeding is annexed with the writ petition. My submission is very much limited, Lordship. That four are absent means meeting has to be adjourned, Lordship. And meeting has to be called by the Deputy Commissioner within 15 days, Lordship. Fixing another date within 15
Yes,
days, Lordship.
you are supporting same.
Yes, ma'am.
Yeah.
The quorum is already reflected in your lordship's earlier order.
Yes. You are for Ahmed for?
I am for my lord, respondent number 9 and 10.
9 and 10. And you are also appearing?
For 12, 16, madam.
Who are those? Who are they?
I am the person present at the 5%.
You are supporting?
Yes. And I rely on section 18
Uh,
of the.
Bhattacharya for R 12 to 16. 12 to 16. What you rely upon what?
18 of the Assam Panchayat.
Section 18.
Yes, section 18.
Yes.
Says the quorum for a meeting of a Gaon Panchayat shall be 1/3 of the total member of the member. So conjoint reading of this provision along with 46(3) would mean that it should be 1.
Okay.
Lordship, so far 18 is concerned, I have a very limited submission, Lordship. 18 will come into play after formation of the Gaon Panchayat, Lordship, after oath, Lordship. This is not for the first meeting, Lordship. This is for the executive meeting of the Gaon Panchayat, Lordship. 18 will not come into this for the first meeting, Lordship. This limited submission, Lordship. For oath and formation of Gaon Panchayat, subsequent meetings, 18 will govern, Lordship. That will be presided over by the President, Lordship. First meeting is presided over by the authorized officer, Lordship.
Okay.
The earlier order, your lordship has directed us to bring the record. Record is available.
We're only on the part of 6. That is not disputed.
No.
Okay. An order dated 10/9/2025, passed by the District Commissioner Vishwanath, by which the first meeting of the 14 number Khiladhari Mukh Gaon Panchayat has been cancelled is the subject matter of challenge in this writ petition. Full stop. In the said first meeting, comma, the petitioner was elected as the president. Full stop. Para. Briefly stated, the petitioner is an elected member of the aforesaid Gaon Panchayat, the elections of which was held on, where was the date of the election?
Lordship. When? Lordship, in the month of May 2025, Lordship.
held in May 2025. Full stop. The first meeting was accordingly convened on 27/6/2025, and admittedly, there were 6 members present, in which the petitioner was elected as the president, and another incumbent amongst the 6 members was elected as the vice president. Full stop. The private respondents herein had, however, submitted a representation against such election before the district commissioner on 4/7/2025, mainly on the contention that the quorum was not fulfilled. Full stop. The complaint states that there should be 7 members present. Full stop. As the said representation was not considered and disposed of, comma, the private respondents numbers, upor number 8, 9, 10, 11, bageta nohoy, upor 8, 9, 10, had instituted WPC 3954 of 2025. Full stop. This court, right order dated 18/7/2025, while issuing notice, had observed that pendency of that writ petition shall not be a bar for disposal of the representation. Full stop. Basing upon such observation, comma, the impugned order has been passed on 10/9/2025, whereby the first meeting was cancelled on the ground of lack of quorum. Full stop. Subsequently, comma, vide an order dated 17/9/2025, the aforesaid writ petition was closed as infructuous. Full stop. Para. It is the aforesaid order dated 10/9/2025, which is the subject matter of challenge as indicated above. Para. I have heard 3 P.P. Datta, learned counsel for the petitioner. I have also heard 3 H. Sharma, learned additional senior advocate for the official respondents. 3 M. Hussain, learned counsel, M.K. Hussain, learned counsel for the respondent numbers 8 and 11, comma, 3 A. M. Ahmed, learned counsel for the respondent numbers 9 and 10, and 3 A. Bhattacharjee, learned counsel for the respondent numbers 12 to 16. You are also there for PNRD. For 1 and I don't say and P. Thapa upwardly here. P. Thapa H. Sharma, sorry, P. Thapa, learned counsel appearing on instruction of 3 S. Datta, standing counsel PNRD. Para. 3 Datta, the learned counsel, has formulated his arguments mainly on 2 grounds. Full stop. Firstly, he has contended that the impugned order has been passed in gross violation of the principles of natural justice. Full stop. Secondly, he has contended that there has been gross misinterpretation of the provisions of law leading to the impugned action. Full stop. Para. Elaborating his submissions, comma, the learned counsel has contended that the impugned action culminating in the order dated 10/9/2025 has been passed without giving any opportunity to the petitioner. Full stop. The petitioner, he submits that the petitioner was in dark when the decision was taken, and thereby the principles of natural justice has been grossly violated. Para. On the second ground, comma, the learned counsel has drawn the attention of this court to the provisions of Rule 46 within bracket 3 of the Assam Panchayat within bracket Constitution bracket close rules 1995 bracket hereinafter called the rules, and has submitted that to hold the first meeting there is a requirement of minimum one third of the total number of members, and it is not in dispute that the total number of members present in the meeting held on 27/6/2025 was 6, full stop. He has submitted that there has been a mechanical application of mind, and the impugned order has been passed, resulting in grave miscarriage of justice. Para. Sri Sharma, the learned senior government advocate, has, however, submitted that the aspect of violation of principles of natural justice would not come in the way of the present challenge, inasmuch as such decision was taken pursuant to an observation made by this court while issuing notice vide order dated 18/7/2025 in WPC 3954 of 2025. Full stop. He has submitted that it is only the matter of interpretation of the statute, as factually there is no dispute. Full stop. As regards the second ground of challenge, comma, the learned state council, by referring to the record, has submitted that the decision-making authority had interpreted that in absence of one third or more members, comma, the meeting is required to be postponed. Full stop. Para. Supporting the impugned decision, comma, Sri Hussain, both Sri Hussain and Sri Ahmed, learned counsel for the respondent numbers 8, 9, 10, and 11, have submitted that a proper and correct interpretation of Rule 46(3) is that if one third or more members are absent, comma, the meeting cannot be held, and therefore there is no error in the impugned order dated 10/9/2025. Full stop. They have also submitted that no prejudice would be suffered by the petitioner if a fresh meeting is conducted wherein the petitioner would have all the opportunity to contest for the post of president. Full stop. Para. Sri A. Bhattacharjee, learned counsel for the respondent numbers 12 to 16, has, however, supported the petitioner. Full stop. He has submitted that his clients were present in the meeting held on 27/6/2025, and the quorum was complete, in which the petitioner was duly elected. Full stop. He has also highlighted that the aspect of presence of 6 numbers of elected members is not disputed by anyone. Para. Para na aro eta koise ha. Tar agot koise ha. Tar agot eta. The Sri Bhattacharya has also referred to section 18 of the Assam Panchayat Act. You have referred to 18, correct? 1994, which lays down the aspect of quorum and procedure. Full stop. He has submitted that as per section 18 within bracket 1, comma, the quorum has been specified to be 1/3 of the total number of members. Para. Sri Hussain, the learned counsel for the respondent numbers 8 and 11, has, however, refuted the aforesaid submission made by Sri Bhattacharya and has submitted that the provisions of section 18 of the Act would come into operation only after the first meeting is held, wherein the president and the vice presidents are elected, and will have no application in the first meeting itself. Para. The rival submissions advanced by the learned counsel for the parties have been duly considered, and the materials placed before this court, including the records in original by Sri Sharma, have been duly considered. Full stop. Before going into the grounds of challenge, comma, it is to be noted that there is no dispute on the factual aspect that in the meeting held on 27/6/2025, 6 numbers of elected ward members were present. Full stop. The grievance of the petitioner, qua the impugned order dated 10/9/2025, has been structured on 2 grounds, namely, 2 grounds indicated above, namely, violation of the principles of natural justice and misinterpretation of the statute holding the field, more specifically, Rule 46 within bracket 3 of the rules. Full stop. Though it is true, though it is correct on the part of the correct that this court, while issuing notice vide order dated 18/7/2025 in WPC 3954 of 2025, an observation was made that pendency shall not be a bar for disposal of the representation, comma, the question would arise as to whether such representation could have been disposed of without giving the petitioner an opportunity. Full stop. The representation was in the nature of a complaint with regard to the election of the petitioner as president of the concerned Gao Panchayat. Full stop. Though the observation that there would be no bar for disposal of the representation was made by this court, comma, it is absolutely necessary, it is imperative for the adjudicating authority to give a proper opportunity to the aggrieved party, which admittedly was not done. Full stop. In the considered opinion of this court, there has been gross violation of the principles of natural justice, as rights which had accrued to the petitioner vide the meeting held on 27/6/2025 has been taken away without giving any opportunity. Full stop. With regard to the second ground of challenge, namely the misinterpretation of the rules, comma, comma, um, uh, this court is of the opinion, the said provisions of the rules are required to be examined, full stop. Then you, intercept paragraph 9 to kore diba, huh? You have to quote kore diba, eta beleg ke kore diba, say 9, full stop. In this connection, comma, the provisions of section 18, which provides for quorum and procedure, is also liable to be taken into consideration. Full stop. Para. Even if it is assumed that section 18 of the Act may not have an application in the adjudication of the present case, comma, the Rule 46(3) quoted above is itself sufficient to govern the first meeting of a Gao Panchayat, full stop. The purpose of laying down a quorum is towards furtherance of an action to elect a president amongst the elected ward members of a Gao Panchayat, full stop. Section 6 of the Act of 1994 has undergone a major amendment in the year 2023, and the earlier position where the president was directly elected by the people has been amended, and presently such president is elected by the elected ward members, full stop. The rule 46(3) quoted above lays down that there should be a requirement of at least 1/3 of the total members for the first meeting to elect the president and the vice president. Vice president. Full stop. The interpretation sought to be advanced on behalf of the respondent numbers 8 to 11 cannot be construed to be a correct interpretation and cannot be said to be in sync with the scheme of the statute, full stop. As noted above, as observed above, comma, there is no dispute with regard to the fact that in the meeting held on 27/6/2025, 6 members were present, full stop. In the considered opinion of this court, comma, presence of 6 members would definitely fulfill the quorum as required under Rule 46(3), even if the aspect of sections 18 is overlooked, full stop. Para. This court is therefore of the view that therefore of the opinion that the view taken by the district commissioner as reflected in the impugned order dated 10/9/2025 is unsustainable in law, and the same is accordingly set aside and quashed, full stop. Consequently, it is directed that the petitioner be allowed to function as the president of the concerned Gao Panchayat in accordance with law and for the tenure prescribed in the statute. Writ petition stands allowed.
Wait, Peter. My lord, apart from anything else, Lord, an election can be questioned only by a
Election of?
petition, election of president of Anchalik Panchayat. So, my lord, as per the act and as per section 129,
Your response number?
7, I am the elected, my lord.
Elected, respondent number 7. Elected president?
Yes.
We have the.
Please have me lord page 142.
Yes.
Section 129.
Yes.
Notwithstanding anything contained in this act, I will have your lordship's
Yes,
kind
yes.
attention to B. No election to any
It
panchayat
is
shall be following.
like 329B, same.
That's it. So now first, secondly, my lord, this petitioner, he has impersonated him with a different name. He is
Your
actually-
election has been put to challenge
Yes.
in the writ petition.
Yes. And there is an interim order also, my lord, while issuing notice, an interim order was passed. Now, if your lordship would kindly take the writ petition for a moment, my lord. Kindly see, my lord, how he describes himself. At page 9.
Of the writ petition.
Yes. Abdul Munaf Sheikh. And you see the name of the father also, name of Nosumuddin Sheikh. আমি এখন কেনেকে পালো? Part of the hearing. Nomination.
Yes.
Now please come to page 26 of the IA, my lord. This is the document which is submitted along with his nomination papers for the member, na? For the election of Gaon Panchayat member. Certified that Abdul Munaf Talukdar. Kindly see my lord ER and kindly see the father's name Nasimuddin Sheikh. Now, my lord, along with the nomination paper at page 28, he also submitted his, my lord, admit card, which was issued to him for appearing in HSLC. Here also his name is shown as Abdul Munaf Talukdar, ER. Now, in the writ petition, my lord, now, my lord will kindly come to page 29. 19th of April. Now, this is an affidavit, my lord, which he has filed. At page 30, Abdul Munaf Sheikh, date of birth so and so, Nusumuddin Sheikh residing at village Hatisingmari in the district of South Salmara, Assam, do hereby solemnly declare as follows. Please come to me, Lord, para 2, that my actual and correct name is Abdul Munaf Sheikh, which has been recorded in my EPI card number, in my Aadhaar card, etc., etc., etc. Then para 3, my lord, that my actual and correct date of birth is 17/11/68, which is recorded in the HSLC and higher secondary admit card, study, etc. But due to mistake, my date of birth has been recorded as 12/11/69 in my Aadhaar card, etc., etc. That whatever the fact may be, both Abdul Munaf Sheikh and Abdul Munaf are the same person. Now this is AR. Earlier it was ER all throughout. Now therefore this affidavit was sworn on, my lord, allegedly on 5th of April 2025. Now, my lord, as far as changing of name is concerned, there is a particular procedure that we have given in page 31. কিন্তু disputation of total কথা বলবো না। Page 31, name change correction procedure. Name change correction procedure goes through 3 steps. Name change affidavit, applicant is to make an affidavit to notary magistrate mentioning his or current name and address and proposed name in the new affidavit. Publish newspaper advertisement. After getting the affidavit, the applicant has to publish an advertisement of his or her name change correction in any national or regional newspaper and notification in the Assam Gazette. For the final stage, application must visit the Director of Printing and Stationery, Bhamani Moidak. Applicant must bring the following. Now, my lord, all these aspects are absolutely silent. In the writ petition, there is no such averment. In the writ petition, my lord, he ought to have mentioned all these things. Now, once he filed the IA, now he has become wiser. In the writ petition, absolutely there is nothing. Therefore, my lord, therefore, as per the law laid down by the Supreme Court, my lord, the petitioner has committed fraud. Therefore, my lord, even solemn acts, I think this writ petition, I think, my lord, if necessary, I can also file a petition under section 340 of the CRPC. It's a serious matter, my lord. Well, I'll just rely on one judgment, my lord. I can joke now.
Which one?
KD Sharma.
KD. Still.
Still authority. My lord, when your lordship has uttered the word still, it reminded me of Borpeta aspect, my lord. Lordship knows Ramesh Khata. Perhaps lordship knows that Girish Mishra, my lord.
Tansen.
Tansen.
Nobody knows him as Girish Mishra.
But he is known more as Girish Tansen. My lord, will kindly come to para 27, my lord.
This is 2008.
Yes, 2008, 12 SCC 481.
Paragraph 12.
27, 28.
Paragraph 28.
27 first, my lord. This is the fraud aspect, and the other aspect is, my lord, when one doesn't come with clean hands, he has no right of audience. Reference was also made to a recent decision of this court in so and so. Considering the English and Indian cases, one of us, Thakkarjee, stated, it is thus a settled proposition of law that a judgment, decree, or order obtained by playing fraud on the court, tribunal, or authority is a nullity and non-est in the eye of law. Such a judgment, decree, or order by the first court or by the final court has to be treated as a nullity by every court, superior, inferior. It can be challenged in any court at any time in appeal, revision, read, or even in collateral proceedings. The court defined fraud as an act of deliberate deception with the design of securing something by taking unfair advantage of another. In fraud, one gains at the loss and cost of the another. Even the most solemn proceeding stands vitiated if they are actuated by fraud.
Yes.
Fraud is thus an extrinsic collateral act which vitiates all judicial acts.
That
whether in-
Lazarus case is quoted in that
Yes.
Justice page 1 judgment. Fraud vitiates everything.
Yes, correct. So
What
therefore,
wrote
my lord, my humble submission is,
This is Kuldeep Nair's judgment.
therefore
First
my
time.
humble submission is, my lord, this writ petitioner is not even entitled to be heard. For that proposition, I'll just read one paragraph, my lord. Para 39. At page 493.
No, are you indicating that the papers and the person are different?
Yes. Because we do not know who is before the court. His actual name is, my lord, when he was in studying in college school, he's now 56 years old. And my lord, that certificate is of maybe when he was under 16 or 17 or 18 years old. And 25th of April.
Affidavit is of which date?
Affidavit is of April 25, just on the eve of the election. It can't be, my lord, that he is not aware that he was talukdar.
Have you filed your rejoinder to file response?
So, my lord, my humble submission is, of course, relying on also on para 39, which says, my lord, para 30, if the primary object.
What are the grounds of challenge, petitioner's challenge?
His ground that my certificate, higher secondary pass certificate is fake.
You are required to be higher secondary
Yes.
pass. So you have not passed. You do not
According
have the
to him, yes.
do not have the qualification.
Yes. You file an election petition. And, my lord, kindly see, if your lordship would kindly have rule sub.
Have you said anything on that allegation?
No, my lord, we are disputing that.
You're disputing?
Yes, yes. If your lordship would kindly come to sub rule 2 of rule 60.
Mr. Mohanto, even if we are not agreeing with Mr. The learned senior counsel for the petitioner. Right. You see, ultimately, if it's a disputed questions of fact,
Yes.
which Mr. Chaudhary has just said, then you have to prove it in accordance with law.
I
And
agree.
you may either file an election petition or it's up to you.
Yes.
But election, the bar is mainly to not to stall the elections. Now you have put a challenge after the election. So this bar may not be strictly applicable. That
insofar
is
as-
what we are thinking. But that will not bring an end to the matter.
Yes. Insofar as the first question is concerned, my lords, whether we should file an election petition, that has already been settled by the division bench of the.
No, that we are not,
Yes, yes.
that is we are not insisting. But once your main allegation that the petitioner does not possess the
The
qualification
Yes.
and which fact has been disputed by the petitioner on
My lord,
affidavit.
I'll completely satisfy my lords. Let my learned friend, learned senior friend complete my lords. I'll just take 5 minutes, my lord. I'll argue on it.
No, how do you, on the
Now, my
eligibility
lords,
part?
first of all, if I may say so, my lords, lordship is taking up the IA, my lords.
No, we're just taking up entire
Taking up-
matter.
My lord is.
Just a
taking-
minute, Mr. Chaudhary will come back.
Yes, yes.
I have understood your case.
My lords, would give me 2 minutes, I'll give you a perspective on the matter, what had happened, my lords. Now, pursuant to
No,
the-
your challenge is based, is it a correct aspect that your challenge is based on the aspect of qualification?
On the aspect of qualification, my lords, I'll very briefly state, my lord, what had happened, my lords.
Please come to prayer at page 23 of the writ petition, my lord.
Writ petition?
Yes, there prayer in the writ petition.
Yes.
Please come to prayer B.
Yes.
A writ in the nature of mandamus shall not be issued.
Disqualified.
Without authority to disqualify respondent from remaining as a member.
Okay.
This is the role of a tribunal. Not 226 power is there, we are not disputing because it's the basic structure of the constitution. But that does not mean, my lord, when and machine, end of the day, when you are raising a question, it has to be decided based on evidence.
This aspect has already been decided, my lord. This is not material to what is. Well, before placing that, I'll briefly place the.
Yes, what is it?
Yes. Well, what had happened pursuant to the recent amendment, my lords, in the Panchayat Act, it was provided to be a Anchalik Panchayat member, you have to be minimum HSLC pass. Yes,
You can just skip this.
Yes, yes.
Those are known.
My lords, what I'm trying to point out, my lords. So when my lords, the elections were held, my lords, the applicant who is the private respondent, my lords, applicant had filed an affidavit, which is on record before the election commission, my lords, stating that by virtue of admit card number so and so and past mark sheet dated so and so, I have passed my HSLC examination.
Okay.
That was stated before the election commission, my lords. Now, pursuant thereto,
pursuant thereto, my lords, number of RTI applications were filed, my lords. RTI applications were filed before the board, my lords, which is now called the Assam, it has amalgamated, my lords, and those mark sheets were produced, my lords. Now, those mark sheets, when these mark sheets were produced, the board, which is a party before my lords, in the writ petition, the board with their own seal and signature had marked those mark sheets as counterfeit, my lords, as counterfeit, and we had annexed those, and I had also produced the original certified copies of the board, my lords, before the honorable court, and that's why interim was granted. My lord is aware it's a public document, certified copy, there's a presumption of genuineness. Whatever may be the case, my lord, look at the audacity of the applicant. Now, what he has done, I'll just read one paragraph from the IA, my lord, what the IA has been filed. My lord, the IA has been filed to vacate the interim order, which was passed because the court had held prima facie that the applicant, who was the respondent, does not possess HSLC, which is a mandatory requirement. It has been certified by the board, my lord. Now, what has been argued by my learned senior friend, I'm so sorry, my lord, is totally alien to the case, my lord. If he has a case against me regarding that name change, I may not answer it now, my lord. There's no writ petition file. In fact, my lord, this Mamun Shah, for the same forgery, my lord, his bail application was listed today, which was the interim was rejected. There's another writ petition pursuant to this writ petition, which my learned senior friend may not be aware, which was filed before this honorable court, my lords, by some other advocate, where this prayer is not there, no interim was granted. Whatever be may the case, my lords, lords, may kindly take up the IA for a moment. It will be crystal clear, my lords. It's a case where costs should be imposed, my lords. My lord, may kindly take up the IA for a moment.
Yes, I
Kindly,
will.
my lords. And my objection may be kept handy, my lords. I'll just read one paragraph. My lord, may come to paragraph 6 of the IA, my lord, page number 8, paragraph 6. Now, page 8, my lord. Now, that mark sheet, like I stated, my lord, that mark sheet and the admit card, which was marked as counterfeit by the board, was produced in the writ petition. So he develops a story, my lord. To defend himself, he files this IA, and lordship would read paragraph 6 for a moment.
Yes.
What has been said there, my lords? That the applicant respondent number 7 begs to state that after the aforesaid re-verification of the marks, the applicant respondent 7 came to learn that the secretary of the erstwhile Assam Higher Secondary Education Council, by letter dated so and so, my lord would kindly note the letter number for a moment, letter number so and so, dated 9/7/2020, informed the principal of Hathi Singhmari Junior College that upon re-verification of marks, the applicant respondent number 7 has been declared to have passed HSLC examination in second division marks with 266. Now, since I had appended those counterfeit mark sheets, he comes up with a different story, and he says that by way of this letter, the board has declared me to have passed HSLC. Now, my lord, may kindly take up the objection for a moment, the affidavit in opposition to the IA. Is playing fraud on the court, my lord. Lordship would firstly take up my RTI application, my lord. And I have the original for my lord's eyes also, my lord. The original, my lord, requires.
Original duplicate are very difficult for us to decipher which is original, which is duplicate.
No, the original signed document.
Signed,
In
everything
the
is-
meantime, I'm reading it, my lord. Page 42.
Of your
My
objection,
objection, my lord. It's marked serially, my lord, page numbers.
42, yes, we have got
42.
42.
This was the specific question, my lord. Kindly find attached.
42 we have got, yes.
Kindly find attached a copy of the letter, wide number so and so, the same number, my lord, which is mentioned in paragraph 6, dated so and so, purportedly issued by the Secretary, Assam Higher Secondary Education Council, addressed to the principal, Hathi Singhmari Junior College, Hathi Singhmari, South Salmara, informing the latter that one Shri Mamun Shah, bearing roll number so and so, is declared to have passed his HS examination 2020 upon revision of his earlier unsuccessful result. Kindly verify and inform with regard to the authenticity of the letter. Now, what is the reply, my lord? My lord would find it at page 43. Original one, page 43. My lord will refer from the original. My lord.
Okay, doesn't matter. 43, yes.
Yes, 43.
Hmm.
Number 1, pertaining to serial number 1, it is to inform you that ASSEB, erstwhile ASSEB, does not have any record of issuing the letter number so-and-so, dated so-and-so. Regarding the authenticity of the letter, the controller of ASSSB had marked and signed the letter as fake. My lord, can you turn the page, my lord? The letter by which he claims to have passed has been again marked as counterfeit and fake by the board.
This reply was on the same date.
Yes, because earlier RTIs were, just because they're efficient, my lords. Earlier also we have filed RTIs. Everyone knows Mamun Shah, my lords, the applicant. Now look at his audacity, my lords.
No, it's okay, but this 28 you.
Yes, same day, yes. Because earlier also I have appended, my lord may take up my additional affidavit also. There were again similar RTIs filed, number of RTIs everywhere. Every document he has furnished.
No, that's okay.
I'm so
that's
sorry.
okay,
I'm so
that's
sorry.
okay.
Now they have filed an application.
No,
for-
see, mudslinging is very easy, but mudslinging is very easy, but your hands will also get soiled.
Exactly.
You
Exactly.
see, in your application, you have not given your father's name, the applicant.
Yes.
In reply, there is a father's name. How is it come?
I'm not aware, my lord.
No. Since you are relying upon this,
I'm so
I'm
sorry.
not, I am not saying that that it may be okay, but same date raises some suspicion.
That is
The name
reason
of the
why I
father
have
comes
made-
in.
Made the board as a party, my lord. Board is a party. Let them come and say they have not issued it, my lord. They have filed an application for vacation of the interim order, and my lord, as an applicant, they have to stand on their own foot, my
No,
lord.
that is okay, but
He's harping on my weaknesses, my lord. Why should I
yes,
reflect that?
those part we are not.
Yes,
Those
yes.
part we are not interested. We have indicated those we are not. We are trying to examine the subject matter
Yes.
involved.
If I-
But at the same time, writ petition, bona fide is required.
Of course.
Clean hands are required.
Yes,
So
yes.
a respondent, he has all the rights to raise this
The
in a court of
applicant,
equity.
my lords, the hands are very dirty, my lords. FIR was filed, my lords. Bail
Counterfeit.
was not granted. It was listed today, my lords. There's another, I'll
Counterfeit.
place another, my lords, writ petition, my lords.
Mr. Chaudhary, why did you file an affidavit in the main case?
Affidavit, we have filed.
Main case.
This can be treated as my affidavit, Miller. Okay, we'll file with my.
Another writ petition, my lords, filed by the same
My
person,
learned.
different
friend,
allegation.
I have heard him saying that I have got audacity, but he haven't explained his conduct, Miller. Whether this writ petition should be heard by this honorable court, whether who is before the honorable court. Talukdar is there or Munaf is before the court.
Well, learned
And
senior
my lord,
friend
he
is for-
passed his
Sorry.
higher secondary
Sorry.
examination way back. And my lord, he files his change of name today, the month of April. Is it believable? As your lordship has rightly pointed out, my
No,
lord, in the
he-
right.
My lords,
he-
the occasion
No,
did
no,
not arise.
Mr. Mohanto, there is another question you have to answer.
Yes,
Yes.
You can change your name later.
yes,
But when did you appear in your examination?
yes. Well,
You had appeared, this information is given on an application by whom?
Which one, my lord?
This which you have just produced, who is this?
The RTI, my lord.
Anarul Islam?
RTI is filed by someone else. There are different RTIs now. In the writ petition also, there's a different RTI, same question, same answer. There's an
No, you
additional,
can take the aid of any
Additional
information. That's not a problem.
and I would answer.
Who is he otherwise? Anarul?
Mhm. Son-in-law of the, I've been told, my lord, son-in-law of the petitioner, writ petitioner. my lord.
Okay, no, not a problem there.
My lords, and the name change affidavit, my lord, like I pointed out, the occasion never arose, my lord, because the amendment is very recent. Before that, HSLC pass was not required. And why will I, and my lord, and if they have any, they have to agitate in their own writ petition, my lords. Can they pray for a prayer in my?
No,
writ petition?
that's not.
Lord, it is not my
Mr.
prayer
Mohanty,
that
it's not
seeking
ours
relief.
yet.
I'm opposing your petition. In
Well,
that opposition, I can
Let my
certainly say
learned
that.
senior friend answer first question of whether it is true or false, my lord. Apparently, my lord, documents are produced which has been marked as fake.
At least we have come up with our version saying we dispute it. But what about your
Mr.
own
Chaudhary,
conduct?
I mean,
No, I'm
you
saying, like,
you file your affidavit. You file your affidavit in the writ petition. We'll try to see, ultimately,
my lord, that interim order is slightly problematic. You know, kindly have a look at the interim order.
No, I have strong objections, my lord,
We'll
for
see,
application
we'll
of the
see.
interim.
Kindly have a look at the interim order. my lord.
Page.
Interim order is at page 18 of the IM. You know.
18.
the operative portion, my lord. Paragraph 8. The petitioner has relied upon information provided by the Assam State School Election Board, which are annexed as Annexure 1 to this also. From the said document, it prima facie transpires the respondent does not have qualification as prescribed in the section so and so. In such view of the matter, it is ordered in the interim that respondent number 7 shall not make any financial decision in respect of the affairs of the respondent number 2, affairs of number 2 so and so. Well, my humble submission is, if a busybody interloper is challenging the election, how can it be entertained? We do not know who is the petitioner, my lord. It's a very serious matter.
Where is his past certificate from council?
No such allegation in the IA, my lord.
And my lord, to show his bona fide, he should bring out all the certificates.
Well, that placed a judgment, my lord, which answers the first question, my lord, whether a election petition is maintainable at all.
No, election petition, we have expressed.
Yes.
That is only not to stall an election.
My lord.
Here elections are there, but ultimately it may boil down to the aspect of disputed questions of.
Yes.
That you have to
is
answer.
fine.
My lord, section
Mr. Chaudhary,
79.
you are not inclined to this,
I'm very grateful.
vacate the interim order for the present.
Yes.
But you file your affidavit. You file your affidavit because this, the primary ground which you had projected, that is the aspect of the qualification which he had alleged, that you did not have the qualification. You have also additionally questioned his bona fide, locus standi, everything. That those will take care in the main writ petition. But this interim order has been.
My humble submission is, my lord, will your lordships entertain a litigant whose very identity is a...
No, that is the.
That is the aspect.
No, that is what we are trying to place to before you. See, the interim order has been passed on the main consideration that you do not possess the
My degree is
educational
established
qualification, which you have said that there is a
prima
document,
facie case.
and that he has disputed by giving another letter from the RTI saying that that certificate is counterfeit. He may be right, you may be right. We do not have the expertise to say who is right. But your contingent so far as questioning is bona fide is concerned, those are still open.
Yes.
Those will not deciding in the IA. We will decide in the writ petition.
My lord,
But we can have the writ petition
make the
very.
position clear.
We will make it very
Yes.
clear. We'll make it
Okay.
clear, very clear. But you'll put everything on record so that Mr. Mahanta will also have a chance to.
Yes.
Very grateful.
We'll do that.
Very grateful.
Heard Sri K.N. Chaudhary, done as senior counsel, assisted by Sri R.M. Deka. You write R.M. R.M. Deka. Who by means of this application has prayed for vacation modification of an interim order dated 12/11/2025 passed in WPC 6405 of 2025, full stop. By the aforesaid interim order, comma, the applicant respondent number 7 was debarred from taking any financial decision in respect of the affairs of the number 2 Hekamari Anchalik Panchayat till the returnable date. Full stop. The primary ground of grant of the interim order is that the applicant did not possess the educational qualification required for such election. Full stop. To overcome the aforesaid ground, comma, the applicant has annexed a document where is that past certificate?
That has not been annexed. It's mentioned in paragraph 6.
No, we have got the original, my lord. We have annexed.
Have you annexed?
Yes, we have got the original.
We
have annexed our IA.
IA.
Where, which page?
Yes.
I think page 23.
Yes.
20. I have the next. Pass certificate issued by the Assam Higher Secondary Education Council. Full stop. The Learned Senior Council has also raised serious objections on the bona fide as well as the conduct of the petitioner in approaching a court of equity. Full stop. It
In
is
a fake name.
It is specifically contended that the name of the petitioner vis-a-vis the documents enclosed appears to be appears to lack bona fide, and he has also alleged fraud in such conduct. Full stop, para. Sri Mohanto, the learned counsel for the opposite party writ petitioner, has however drawn the attention of this court to the objection filed in the IA and has contended that the Assam Higher Secondary Education Council has itself marked the communication dated 9/7/2020 as counterfeit. Full stop. Para. Though this court, in exercise of writ jurisdiction, may not have the expertise to go into the authenticity, veracity of the rival documents, comma, this court is of the opinion that instead of adjudicating or making any remarks in the IA, comma, the entire writ petition can be taken up for disposal. Full stop. The applicant, respondent number 7, is accordingly directed to file affidavit in opposition, bringing on record all the relevant facts, including the objection on the maintainability, which has been put up in the IA. Full stop. The petitioner, the opposite party writ petitioner would have the liberty to file rejoinder affidavit. Full stop. The while this court has, it is made clear that while this court has refused to, has declined to vacate the interim order, comma, no opinion has been expressed on the aspect of bona fide raised by the opposite party on the conduct of the petitioner, which will be decided in the writ petition.
Deeply obliged.
Lord, may kindly give a date, my lord.
Please tell us.
From position. My lord, reopening, my lord. After reopening.
Can we have it on 21st or 22nd?
Yes.
21st is the Wednesday
Or could it be in the first week, my lord?
of January.
January.
If you can,
Yes.
Second week of January.
Second week is all holiday because of
Second
Bihu.
Bihu, no.
Bihu.
Either-
Then we can have on 20th, 20.
20th.
Tuesday. But ensure that pleadings are over.
No, we'll do definitely. By very opening, reopening, they will file the affidavit.
Deeply.
This original or whatever you
Yes,
can
I'll
take
take
it back.
it back. The main case, the interim needs to be extended.
Interim order in the main case, you're right. In view of the order passed in I 3859 of 2025 today, comma, the interim order passed earlier stands extended till the next date fixed. As agreed to list on 20/1/2026.
Deeply
By which
obliged.
date
Deeply.
pleadings are required to be completed.
Deeply obliged, man. Very grateful.